The petitioner, where is the confirmation letter?
This is the approval. For secondary, it is not confirmation, it is approval. Approval is at page number. That is page number 27.
Approved on?
It was on 28th of February 2020.
The service of the petitioner was duly approved by the concerned authority on 28th February 2020. This is general transfer.
General transfer.
The petitioner's residence is about 555 kilometers away from her present place of posting. On which date you made an application?
The application date is
5th December.
Yes, my lord.
On 5th December 2025, the petitioner made an application offline seeking transfer. The application of the petitioner was forwarded to the District Inspector of Schools AC, Jalpaiguri. Respond number?
Yes, my lord. The respondent number is 5.
Yes. By the school authority. School forwarded this to TI on which day?
This is possibly 9th December 2025. That would appear from page 97. Subject regarding your transfer prayer dated.
Yes. 9th December 2020. The District Inspector of Schools AC Jalpaiguri did not consider such prayer for transfer on the ground that the Utsosri portal has been temporarily suspended. Being aggrieved by such action of the respond number such and such, District Inspector of AC Jalpaiguri, the petitioner has preferred the present writ petition. Mr. Subhru Prakash ID, learned advocate for the petitioner, submits that the mere suspension of the portal cannot ipso facto repeal the statutory province nor can curtail such statutory right, and therefore it was obligatory on the part of the District Inspector of Schools AC Jalpaiguri to process the application of the petitioner seeking transfer furnished offline. To buttress his contention, he relies on decision of Honorable Division Bench passed in Mithun Roy versus State of West Bengal and others, Remat 1706 of 2024. He seeks for setting aside of the impugned letter of respond number 5 dated 12 February 2026 with a further direction for consideration of the prayer of the petitioner seeking transfer. Mr. Sunit Kumar Roy, learned advocate appearing for West Bengal School Service Commission through virtual mode, also concedes to the submissions advanced on behalf of the petitioner. Yes, Ms. Singh.
Yes, Doctor.
Ms. Supriya Singh, learned advocate for the state rate colony, leaves the matter to the discretion of the court. Upon hearing the learned advocates for respective parties, the only issue which falls for consideration is whether the impugned letter dated 12th February 2024 issued by District Inspector of Schools AC Jalpaiguri
26.
is sustainable or not?
26. 12th
Upon
February 26.
upon perusal of the impugned letter of response number 5 dated 12th February 2024, it is found that this application of the petitioner seeking transfer has not been considered on the ground that the Utsosri portal has been temporarily suspended till 30th June 2024 or until further order. At this stage, it will be profitable to reproduce the relevant portion of the judgment of Honorable Division Bench passed in Mithun by Para 9. Bearing in mind the aforesaid observation of the Honorable Division Bench, the impugned letter dated of response number 5 dated 12th February 2024 is hereby set aside.
2026. It will be 2026.
26.
6. All will be 12th February 2026.
26 of it
12th February.
set aside. Accordingly, the response number 5, District Inspector of Schools AC Jalpaiguri, is directed to consider.
DI will forward it to the School Service Commission.
First, consider
Due consideration, you will forward. Consider the
Yes.
application seeking
Yes.
transfer the petitioner and take consequential steps by forwarding the same to the West Bengal School Service Commission for further action within a period of 6 weeks from date of communication of this order, disposed of.
And Commission will take consequential steps because otherwise
Other consequential steps shall be taken by the School Service, West Bengal School Service Commission upon receipt thereof
in time-bound manner.
within a period of 4 weeks thereof.
I'm grateful. Much obliged to your lordship. Madam, for the petitioner, this is the secondary transfer application. It has been forwarded to the DI. It is pending at the end of the DI. DI is to consider and forward it to the commission. My lord, kindly come to page 108. It is on self-medical ground.
My lord, I am for the commission, my lord. My lord, here, my lord, the role of the DI is first, my lord, DI has to take an opinion of the CMOH. And if the CMOH report suggests for transfer, then the DI will forward the transfer application along with the medical report to the Central School Service Commission for further consideration.
Yes, in accordance with law, it is the provision in the law itself.
This has been forwarded by the school.
School has already given NOC and forwarded to the DI. So DI is to
Yes,
consider.
for state.
Yes, DI is to consider.
What is your instruction?
Actually, just now I received a WhatsApp message from the AI. Sir, as per their version, as per available records, reach of WPA 685-2026 of Jahanara Khatun has not been served to me.
That's all. Sorry, my lord.
No, sorry.
Has it been forwarded from the DIZ?
Yes,
No, it is
10.
pending at the DI. DI has to take a decision.
He has to consider and
Yes,
forward
he
it
has to
to
take a
the,
decision.
if he is eligible, he will forward it to the
Yes,
School
yes,
Service
my
Commission.
Full service.
Ashun, by the present writ petition, the petitioner seeks direction upon the respondent authorities.
Yes. Respond number 5.
Respond number
5.
respond of the particular respond number 5
DI of school AC Kuch Bihar.
to grant transfer in favor of the petitioner to any school
Not any school, my lord. The preferences have been given in the application to the preferred schools.
to any of the schools preferred by the petitioner. The petitioner contends that she is an assistant teacher of Buskadanga Bholanath High School, joined on 19 September 2008. The service of the petitioner has been duly approved by the concerned authority on 27 November 2008. तो join करो. Subsequent thereto, the petitioner was mutually transferred to Hajrat Harishchandra, no, Hajrahat, sorry,
Hajra.
Hajrat Harishchandra High School, video order dated 4th August 2012, where the petitioner joined on 11th August 2012. The service of the petitioner has been approved by the concerned authority. So every time you join a new school, the approval has to be there?
Yes, my lord.
Yes,
Case
my lord.
31 is my new.
The district
6
inspector of
September
schools-
2012
2012.
has already granted approval in the
Okay.
new school. 6 September 2012.
12. The petitioner is suffering from severe gynecological disorder, including sub intra three, coupled with numerous intramural and subserosal fibroids in uterus, and is under regular treatment and medication. On which is the date of the application?
Date is, my lord, date of the application is
14
14 January. 14 January.
On
2026.
14 January 2026, the petitioner made an application before the school authority seeking transfer. On 21st January 2026, the application of the petitioner seeking transfer has been forwarded to the respond number district
5.
Five.
DIF schools AC
District
Kuch Bihar.
Inspector Schools AC Kuch Bihar. However, no steps have been taken as yet by respond number 5. Stop hence this writ petition. Mr. Subhra Prakash Laidi, learned advocate for the petitioner, submits that the district inspector of the school be directed to consider the application of the petitioner seeking transfer and forward the same to the School Service Commission, West Bengal School Service Commission, for further consequential action. Mr. Sunit Kumar Roy, learned advocate representing West Bengal, respondent West Bengal
Central
School Service Commission, School Service Commission, Central. ওটা তাই করে দেবেন। Submits that the District Inspector of Schools AC Kuch Bihar has to consider, after examination of the petitioner by CMH of the district regarding her medical ground, and on being satisfied, the same has to be forwarded to the School Service, Central School Service Commission for further action. An advocate for the state, Mr. Swanso, leaves the matter to the discretion of the court. In view of the submissions, it is found from letter dated 21st January 2026 of the headmaster of the school that the application seeking transfer of the petitioner has been forwarded to the District Inspector of Schools AC Kuch Bihar. Admittedly, the application of the petitioner seeking transfer is pending at the end of the District Inspector of Schools AC Kuch Bihar. Upon considering the submissions advanced on behalf of the respective parties, the same District Inspector of Schools consider and forward the same, if found eligible, shall forward the same to the West Bengal Central School Service Commission for
Along with
further
the medical report.
consequential steps in
Along with
accordance with
medical-
law, along with medical report, which shall take steps in 6 weeks, not to 4 weeks, on receipt thereof, disposed of.
Well, only add one line, the temporary suspension of portal will be no ground to withhold the transfer application. because
There is no such ground.
no, it happens usually. These lines are added in the principal print because these things happen.
No, no.
My lord. Your lordship has seen in other DIs they have done it, so it will unnecessarily. My lord. Just an observation, my lord.
No.
Very well, my lord. Grateful to your lord.
Yeah.
Obliged, my lord. Much obliged.
No,
But
for
item
the,
number 6, I'm for the petitioner. My lord, this also a transfer of my lord a clerk of the Group C clerk of the school of a government aided state school below. My lord, petitioner applied for her transfer on general ground in prescribed pro forma, which start from page 18 and onwards. My lord, dated is my lord 6th of April 2026. My lord, it is pending before the school authority. As usual, school authority has not taken any decision to that effect. I am only praying let the school authority be considered it, and if the petitioner is otherwise eligible, shall be forward to the DI, and DI shall take all of the onwards processing in accordance with law. That much I am saying. It's an innocuous prayer.
sir, kindly come to page number 18, my lord.
Yes.
18 and 19, my lord.
Yes.
Kindly see that application date, my lord, blank.
My lord, I have speed post. I have making speed post page 23. Is a receipt of page 23. It has forwarded
No, which
6th
date
of
they have
April.
made, my lord?
6th of April 2026.
Page number 19, my lord. Blank. 8, column 8.
My
Blank.
lord, it is a prescribed pro forma. Sometimes due to technicality, they have sometimes missed, my lord, this column. My lord, however, I have stated in my application also on oath I have stated and postal receipt I have annexed. So which is, my lord, more
Six.
prioritized, whether it is a technical error or oath on my oath on affidavit I have stated 23rd of April, 6th of April 2026 I have submitted to the school authority.
My lord,
School
I am
constitution-
appearing on
Yes.
behalf of the School Service Commission in this matter, my lord. My lord, if your lordship kindly turns to page 21, that is, this is the most essential document which is required to be filled up by the school authority. My lord, the issue is pending before the school authority. Now, my lord, the school authority has to issue necessary
Yes,
no
yes,
objection certificate in
yes.
favor of the petitioner.
School
And
has not
after
considered
issuance of
it.
this no objection certificate, then, my lord, school authority will forward the same to the district
Yes,
inspector of
yes, I
schools.
have submitted
My lord,
if I
here,
am
my lord,
otherwise eligible.
The affidavit of the card on behalf of the petition is taken on record by the present petition. The petitioner seeks direction upon the respondent authorities. School. School servers.
नाम पे तो दिया है।
Affidavit of sufficiency. Seeks direction upon the respondent authorities to consider the transfer application of the petitioner dated 6th April 2026 in accordance with law and take all consequential steps thereon. The petitioner contains that he joined as an
My lord, C.
assistant teacher.
My lord, C.
She joined as an assistant teacher on which date? No,
My lord, I
assistant, he
have
joined as
joined,
a group C clerk.
Group C clerk, my lord.
Group C,
Yes.
group C clerk.
30th August 2014.
No, it is
Oh,
4th September
4th
2014.
September, pardon. 4th September 2014, paragraph 4.
4th September 2014. Huh? Para 4. In Nilkuthi, Sister Nivedita Girls High School, HS, District Kuch Bihar. The service of the petitioner has been approved on 20th 11/2014. Since the Utsosri portal remained suspended, the petitioner applied for a transfer through offline on 6th April 2026 in prescribed format to the school authority
My lord,
Oh, yeah.
my lord, it is ground
The,
is my lord widow ground. My lord, petitioner is a widow lady. It is a widow
ground
ground. It's a widow ground. I have stated as it's paragraph 7. My lord.
on a widow ground.
Yes.
However, the same is still pending at the end of the school authority. Hence this writ petition. Mr. Sudeep Ghosh Chaudhary, learned advocate appearing for the petitioner, submits that the school authority is under obligation to consider the application and forward the same to, this will be through DI,
Yes, yes. To the DI, then first to the
DI.
DI, then
District
SSC.
Inspector of Schools, AC. However, no steps have been taken. He seeks for appropriate orders. Mr. Shumit Kumar Roy, learned advocate appearing for West Bengal Central School Service Commission, submits that the school upon considerations has to submit a no objection certificate, and thereafter further steps will be taken in accordance with law. Mr. Orijit Ghosh, learned advocate for the state respondents, leaves the matter to the discretion of the court. It is found from the annexure is E17 that the petitioner has made an application before the school authority, which was sent through post on 6th April 2026, seeking her transfer. It is not in dispute that the same is pending at the end of the school authority. Accordingly, despite service, none appears on behalf of the respondent number 5, head of the institution, Nilkuti, Sister Nivedita, High School. Respondent number 5 is directed to consider the application of the petitioner dated 6th April 2026 seeking transfer, and if found eligible, and in the event the petition is found eligible, shall take all consequential steps within a period of 6 weeks from date of communication of the order. Disposed of.
Great. Great.
But one thing, my lord, the page number 23, if you will see, that who is Detri Royal Enclave Advocate? My lord, what is this? My lord? This is the school address, my lord. Page number 23, my lord. Postal address says, my lord, Detri Royal Enclave.
What is the address of? Wait.
Nilkuti Sister Nivedita Girls High School. Okay. Kuchbihar.
No, in 23 he says that it has been sent to some enclave.
Oh, I see, my lord. In that event, my lord, since my lord, it has admittedly, my lord, only one line be added. If any representation application is not made, liberty be given. If not made, petitioner is a liberty to file a fresh seeking fresh application, my lord. It is true, my lord. It is I have stated, my lord. Possibly, my lord, due to communication in read petition, petitioner also affirmed it, my lord. It has communicated, but possibly the wrong document has vanished. It is true, but liberty is given, my lord. No issue.
Then
My lord, I have stated in my application on oath, my lord. On oath, I have stated.
Mr. Orijit Ghosh, learned advocate for state respondent, indicates that the application of the petitioner is bereft of any date. The further, in page 23, the address of the school authority is not reflected. In reply, Mr. Chaudhary, learned advocate for the petitioner, submits that on oath, the petitioner has stated that the date of application is 6th April. If any করে দিন যেখানে ডিরেকশনটা দেওয়া আছে school authority consider the application if any furnished by the petitioner. Dated this. If there is no such application, there is no question of consideration.
My lord, only one thing.
Yes, yes.
My lord, only one.
That may be
If any
reflected in the
application is
order.
furnished, yes.
That may be reflected in the order.
Yes, if
It
any.
is,
Yes, sir.
my lord, only one line. My lord, it is true, my lord, the application has made. My lord, subsequently, if my lord, I am.
That is what. If
My lord,
if it is filed with the authority, then it will take steps. So you add the line that if any has been furnished on 6th April 2026, they will consider that.
My lord,
If it is not submitted, then
My lord, kindly do not mention the date if any application be given. Only in this.
no,
since the-
it is your averment that 6th
Lord,
April is the date. So
Lord,
I mention if any.
Lord,
6th April.
Item 7.
Item 7, my lord, I am for the petitioner. My lord, issue is similar. My lord, petitioner is seeking transfer on my lord itself medical ground. My lord, pro forma wise application offline mode, and it is pending before the school authority without any consideration by the school authority. Your lordship may kindly see the page number 23. Page number 23 is my transfer application. And my lord, it has been duly properly communicated to the school authority on 14th of March 2026. That is page 28. Page 28, it has properly, my lord, sent. And my lord, it is pending consideration before the school authority. I am seeking similar relief. My lord, it is medical ground transfer, self medical ground transfer, ground to only grounds to be, my lord, corrected. It's the
Well,
previous.
have you stated in your application?
My lord, my
In
I
medical
have
ground,
stated-
my lord, the school authority, prior to issuance of no objection certificate, has to take an opinion of the concerned BOMH of the concerned area. And if BOMH
So we'll
report
consider.
suggests for transfer,
Yes, yes, yes. My lord, yes.
then my lord, block medical health officer report suggests for transfer, then my lord, the school authority will issue NOC and forward it to the district inspector of school for further
Okay.
medical examination by the
Yes.
CMOH.
Ghosh,
Plus same Millard, the school name is different Millard and it is not page number Millard.
school name is different.
Yes,
No,
Millard.
nothing. School name is not different. My lord. It's a teacher, Bahu Gang Ghat Jalpaiguri. My lord, kindly see
So
page.
what have
28.
we annexed?
Millard, it is the Harabari High School. As Millard, Millard, it is not legible Millard, but
Harabari, yes.
Harabari, the school is different Millard.
So check
Ghat.
this.
Same,
Some
my lord,
Ghat
same,
Millard.
my lord. If application is made, my lord, I am playing similar relief. I have stated, my lord, they have given me this document and on oath I have stated.
It is, my lord, it's okay because, my lord, the PIN number is also same, my lord. The PIN number
number is
stated in
same.
the PIN number stated in the cost title and the report are
735135.
same, my lord.
735135.
The PIN number may be same Millard, the school is different.
So you have sent it to some ghat.
Yes, Millard. PIN number may be same.
My lord, only, my lord,
The PIN
in this conspectus, in this difficulties arises, my lord, I am praying only liberty to file a fresh medical application, which shall be considered by the school authority in accordance. That will be purpose of the petition.
No,
will
then
be-
you withdraw the writ petition, file a fresh application and then seek for that.
My lord, it will
Without any
some-
document, you say.
No, my lord, I am praying, my lord, I have on oath I have stated, it has been communicated, my lord, kindly give me that order, my lord, previous, just like previous. If any application submitted, then it will be considered by the school authority. Since my lord has passed an order, I am praying, my lord, it is kindly considered this. They are, my lord, on oath I have stated.
But here the name of the school is different.
On oath,
You
my
have
lord,
sent to some other school. The application is probably not submitted.
my lord, kindly pass
That
this
is your
order, my lord.
application.
My lord, application is, my lord, page 23. Page 23, I can, my lord, only, my lord, kindly dispose it of by granting liberty to file a fresh application purpose of the petitioner will fulfill.
Oh,
My lord, it will not, my lord, nobody's right will prejudice, and it is a innocuous prayer, my lord. My lord, it is an innocuous prayer. My lord, it is a medical ground is involved. Kindly consider. It is not a general transfer application. My lord, kindly.
you're sending it to some other school.
My lord, it is possibly, my lord, if any wrong committed, it can be discretion of the court. My lord, it is an, my lord, give me liberty to file. It is not considered yet by the school authority. If this application is made,
Yes,
or
and
it
it's
is
correct. It is correct. The postal receipt is correct.
Malad-
What you are not submitting is the place where the
Malad,
school is situated.
Yes, my lord, pin number is
kindly
same. Some
turns to
different.
page 10 once. Malad, kindly turns to page 10 once.
It is correct. Mr. Ghosh, it's correct.
Yes, your
The
lordship.
name of the school
Malad,
is
Farabari,
Harabari High
page
School,
10.
Yes, your lordship.
but it is
Address is
situated in
Malad Sadhur Hart.
Sahudangi Hut.
Yes, your lordship.
So probably the place is less, is teacher in charge, and the name of the school is missing. But the place is correct. Sahudangi Hut.
But one pin number, my lord, there may be different.
We consider.
Yes.
Ashur, say.
Great.
Affidavit of service filed on behalf of the petitioner is taken on record or if submitted further. Yola. By the present writ petition, the petitioner seeks for consideration,
Senior
seeks
government.
direction for the
advocate
respondent
from
authorities to transfer recommendation in favor of the petitioner on her self-medical ground. Upon consideration of her application dated 14th March 2026. Petitioner contends that she joined as an assistant teacher in Farabari Junior High School of Bhelkipada, Farabari district, Jalpaiguri on 24th December 2013.
Yes.
The petitioner's service has been approved on 15th March 2016. The residence of the petitioner is situated about 366 kilometers from her present place of posting. The petitioner is suffering from serious gynecological disorder. On 14th, the petitioner, since the Utsasri portal remained suspended, the petitioner applied offline seeking transfer on 14th March 2026 on her self-medical ground before the school authority. However, the same has not been considered as yet by the school authority, hence this writ petition. Baki submission same. Okano diben if applied for.
And my lord,
Open.
ground is
Yete.
medical ground. My lord, that ground, yes.
The medical ground.
Yes, Great.
Considered in accordance with law.
My lord, my objection may be, my lord.
Mr. Orijit Ghosh, learned advocate. Mr. Royal submission same. Mr. Orijit Ghosh, learned advocate for the state respondents, indicates that the receipt, postal receipt, shows that the same has been sent to teacher in charge, Sahudangi Hut, Jalpaiguri, and not to the school concerned. It is found that the place where the school is situated is Sahudangi Ghat. The petitioner on oath has stated that she has submitted such application before the school authority on 14th March 2026.
Great.
Grateful.
Disposed.
Great.
Yes,
এটা ভালো
thank
করে করুন, এটা ভালো করে করুন।
My lord, item 8, and for the petitioner, my lord, it is transfer on primary
I
school.
am appearing for the primary board meeting.
transfer of a primary school teacher, my lord. It is transferred on self-medical ground, my lord. My lord, at the medical ground, please kindly. Well, it is a child medical ground. Paragraph my transfer application is page 27. It is
From
transferred.
which district to which district?
Yes, yes. It is
Inter-district?
Jalpaiguri. Yes, yes. Inter-district. It is from Jalpaiguri to Purulia. Jalpaiguri to Purulia.
Jal-
Child medical ground. My lord, board is the authority. I made a transfer application. Page 27, my lord. 6th of April 2026.
Inform the learned advocate for the board.
My lord, board is here. my
Inform,
lord.
sir.
Board
Where
is
is-
not.
I'm
Mr.
attending the board, yes.
Vikramaditya. Yes, yes. He is at here.
I'm led by Mr. Vikramaditya.
Yes, yes.
Okay.
Only to consider by the board. Nothing more. My lord has dealt with several matters
Fair.
principally.
So self-medical ground.
Yes, a spouse, a child medical ground. 6-year-old son, my daughter Oshmita Pal is heart surgery under the my lord, in CMC Bhelor. My lord, then cardiac problem, child medical ground. My lord, cardiac problem is a listed disease under the my lord, transfer rule. Your lordship dealt with several
Affidavit
matters.
service filed on behalf of you are for the state.
Yes.
Filed on behalf of the petitioner is taken on record by the present writ petition. The petitioner seeks direction upon the responding authorities to grant transfer from which district?
My lord,
From district
from Jalpaiguri to Purulia.
To Purulia.
Jalpaiguri to Purulia on child medical ground.
Yes, my lord.
The petitioner contains that she joined as an assistant teacher in Lakshmi Kanto Tea Garden Primary School. On which date you joined?
My lord, I have joined on my lord, 6th of
6 March
March.
2024.
Yes, yes, yes. 6 March 2024. My lord, 2 years confirmed. 2 years service has effected, but confirmation has not been issued. 2 years I have
The
completed.
petitioner has completed more than 2 years of service. The distance the petitioner's residence distance is situated about 653 kilometers from her present place of posting. The minor daughter of the petitioner, aged 6 years, is suffering from serious cardiac problem. On 6th April 2025, the petitioner, where is your
2026. 6 April 2026. That is
6
page
April
27.
2026.
Page 27. my lord.
6th April 2026, the petitioner made an application seeking transfer before the concerned authority. However, the same is still pending consideration, hence this writ petition.
My lord, respondent number 3 to consider this.
Response number 3.
Yes, the secretary was from the
Yes,
board
sir.
of finance.
Should the board show the learned advocate for the petitioner service that the matter be relegated to the board to consider the application of the petitioner seeking transfer on medical ground. Learned advocate for the board as well as state respondents leaves the matter to the discretion of the court. Similar order, 6 weeks from date of communication, subject to production of all medical documents in accordance with law. Notice upon notice, the reason order shall be communicated. It is made clear that this order has been passed under special circumstances and shall not be treated as a precedent.
I'm grateful, extremely grateful.
Grateful, Your Lordship.
Item 9.
Item 9, I'm appearing on behalf of the petitioner, Your Lordship. The husband of the petitioner died and Your Lordship, the husband of the petitioner died on 18th February, on 2nd of January 2024, Your Lordship. And the petitioner, she got her pension on 18th of February 2025, Your Lordship, after passing of almost 11 months, Your Lordship. So I'm here, this is my affidavit of service that will be taken on record, Your Lordship, and I'm paying for interest on the
Yes.
gratuity amount, Your Lordship.
Yes, state.
Can we dispose of?
No, up to the discretion of the learned.
Affidavit of service filed on behalf of the petitioner is taken on record. By the present writ petition, the petitioner seeks direction upon the respondent authorities for disbursement of interest on gratuity as well as arrear pension from the date following the date of death of the petitioner's husband till the date of actual payment.
2nd January 2024.
The petitioner contains that her husband late Shubho Broto, duto banan ache, Shubho Broto and Shubho Broto Sengupto was an assistant teacher of Rathir Hat BFP school under Moinaguri North Circle in the district of Jalpaiguri. The petitioner's husband, he was in service. While in service, he died.
Yes, Your Lordship.
The petitioner's husband died in harness on 2nd January 2024. That is 2nd January 2024. The pension payment order was issued on 8th February 2025. The gratuity and arrear pension was disbursed to the petitioner on 18th February 2025. However, no interest was paid in this writ petition. Ms. Asa Acharya, learned advocate, appearing for the petitioner, submits that the gratuity and arrear pension was disbursed after almost 11 months, and as such, the petitioner is entitled to interest on such amount due to delay on the part of the disbursing authority. Learned advocate representing the state respondents leaves the matter to the discretion of the court. It is found from the contention made in the writ petition that there is delay of 11 months in disbursement of the arrear and gratuity amount. Accordingly, the petitioner is entitled to interest on the delayed payment of the aforesaid amount, 8% within a period of 6 weeks from date of communication of this order. From the date following the date of death of the deceased employee till the date of actual payment. Disposed of.
Your Lordship, direction may be passed upon the Director of Pension.
Director
will be-
Pension and Treasury Officer.
Yes. 2 and 5. Respondent
2 and
number 2 and 5, Your Lordship. Deeply obliged, Your Lordship. Grateful, Your Lordship.
Item 10.
Lord, I'm for the petition in this matter. My transfer application was again on that temporary suspension of portal. It has been
Okay.
refused, my lord.
Not considered.
Not considered. Page 126.
Similar order like which one you moved in?
4, item number 4.
4.
Page 126 is the impugned order, 9th March 2026.
One 26. Here, another ground has been taken that no transfer of assistant teacher will be considered in order to ensure smooth completion of this process.
That is regarding, that notification is regarding online transfer applications, not offline.
Oh, this is your is offline.
Mine is offline application.
Submissions গুলো same হবে, item number 4. Facta বলে দিচ্ছি. Mr. Roy, the submissions will be same, directions will be same in this case?
Yes, yes. Yes.
Only one clarification I need to give to your lordship. My lord, one clarification is required. One clarification, because since your lordship records the date of joining and appointment, my lord, he was of 2013 actually, but due to court case, he was appointed in 2023. But as per the court's order, court has given the effect from 1st of November 2013, notional effect. So his joining is to be reckoned from that date. That much, your lordship, in summary, that much your lordship can, my lord, record. And commissioner has also accepted the same. Is given notional effect from 1st of November 2013, though letter of appointment was issued on 2023.
Your lordship, may I submit? As per my instruction, your lordship, it states almost same as page 126. That is my
Same
instruction. So due to that, your lordship,
That
the
has been
applications
decided
are
item 4. Yes.
not getting considered, your lordship.
Affidavit of service. We have filed on the
Previously, my lord, it has been.
by the present writ petition, the petitioner seeks for setting aside and the quashing of the memorandum dated 9th March 2026 issued by District Inspector of Schools AC Alipurduar, respond number
5.
5, and thereby not to give any effect to the same. The petitioner contains that he participated in 12th regional level selection test in the year 2011. However, after several litigations, the petitioner was issued appointment letter
In 2023,
in the year 2023, and he joined in this third year itself, 2023. The petitioner filed a writ petition being WPA 6253 of 2025, which was disposed of seeking for notional benefit in view of delay occurred in appointment of the petitioner. The writ petition was disposed of on 2nd April 2025, directing for grant of notional benefit to the petitioner from November 2013. On this is a general transfer or a medical ground?
this is general transfer. Paragraph 9.
Residence of the petitioner is situated over 314 kilometers from his present place of posting. Is transferred from which district to district? Or?
Yes, he wants to come to, my lord, Uttar Dinajpur from Alipurduar. From Alipurduar to Uttar Dinajpur.
Recently, the petitioner is an assistant teacher of which school?
Yes, he is an assistant teacher of Dhonopati Toto Memorial High School.
Dhanopati.
Toto Memorial High School.
In which paragraph you have stated?
That is in the cause title, my lord. That is paragraph, page number 5, paragraph 3, starting from page number 4, bottom.
Dhanapati Toto Memorial High School.
Nice.
Paragraph number?
Paragraph number 3, page number 5.
Yes. The date of joining, 12th December 2023. বাকি দুটো সেম বাকিটা আপনি ওই আইটেম নাম্বার 4 এ যেটা আছে সাবমিশন ছিল সেম রেস্ট ইজ সেম
Rest is same. So your lordship may refer to the impugned order date 9th of March 2026. That would be different. And
you know if
the application date
9th March 2026
and application date is 13th February 2026.
application date 13th February
2026. And DI, so this is this is Alipurduar.
DI Alipurduar, that was Kuch Bihar.
That was Jalpaiguri, na?
Jalpaiguri.
This is Alipurduar.
Yes, Mr. Roy, this on similar lines this order is passed. Huh?
Yes, my lord.
Directing the DI to consider the application and take consequential steps.
Yes. I'm grateful to your lordship.
Dispose of.
Much obliged. I'm grateful to your lordship for granting me opportunity.
Thank
I will trouble your lordship again after a few days.
Okay,
I'm
thank
grateful
you.
to your lordship.
My lordship, I am appearing on behalf of the petitioner. Affidavit service has not completed.
The
I
advocate for
kindly
the
request you-
petitioner seeks accommodation to complete service
On
upon the
16th.
respondents. Place this matter before the next available circuit bench.
State is appearing, Lordship.
Oh, state
Grateful
is
to you, Lordship.
represented. Then what remains?
Sir, ZDA is not appearing. ZDA is not appearing. Siliguri Jalpaiguri
State
Development
is
Authority.
represented. Kodum babu?
কেন এই মামলার মধ্যে কেন
11. Item 11.
An advocate for the petitioner seeks to complete service upon the respondents, seeks accommodation. State is represented.
What item number?
Petitioner is directed to serve on
এটা কত নম্বরে আছে মন্ডলটা? হ্যাঁ কত নম্বরে আছে?
only then he has to serve upon
এখানে দেখেন
respond
না,
number
এখানে।
3 and 4.
Lordship,
2, 3 and 4.
Yes, Lordship.
for SGD we are appealing, Lordship directs them to serve a copy of.
So you are appearing.
We
But
can
they-
take
Then
instructions.
all are appearing.
all are appearing.
Yes,
If
Lordship.
if Lordship directs them to serve a copy directly upon us,
Oh.
then Lordship we can take instructions.
20.
20.
Okay, কেটে দিন। Learned advocate for the petitioner informs that the service is not complete. Be that as it may, the state respondents and Siliguri Jalpaiguri Development Authority is represented. Both learned advocates representing state respondents and SJDA seeks that copy of the writ petition and its annexes be served upon them. Learned advocate for the petitioner undertakes to serve the copy of the writ petition and annexures upon state respondents and SJDA. Is this matter coming next week?
16th
Monday,
June.
Lordship, 15th.
15th June.
15th June.
16th.
16th.
16th June, Lordship.
16th June.
16th.
Yes.
Sure, take.
কুড়ি তো?
Grateful to you.
Number 12.
Well, Lordship, I am for the petitioner.
this is a matter, my lord, where in the land of the petitioner, my lord, Dishnet Wireless Limited. Subsequently, it has been, my lord, taken by the GTL infrastructure, which is registered under the telecommunication department. Now, my lord, the installation of the mobile tower, there was a deed of license executed between the petitioner and the company, and the tenure of the license was for 12 years, which has been expired in the year 2020. But they have stopped paying rent from 2018. I am not on that, but the license admittedly expired in the year 2020. My lord, that there was no renewal of the license. The petitioner made a request to the authority concerned to remove of the tower because it is lying, my lord, it is standing.
GTL, this is Union of India.
Union of India. My lord, it is, my lord, standing, my lord, uselessly, my lord, the land of the petitioner is getting wastage, and my lord, it is also dangerous for the local people. So, my lord, the request has been made from the by the petitioner to the GTL to remove. My lord, that has not been taken care of. My lord, the
I am
representation.
appearing for Union of India. I am not representing GTL, Lordship, and
My lord, my
Lordship here.
service, my lord, all
Where in this
affected.
case, mainly answering respondent is 2 and 6.
Now, my lord, the petitioner made a representation to the district magistrate because, my lord, as per the section 18 of the Telecommunication Act, removal of the tower, the district magistrate is the authority. If it is regarding the compensation, then district judge. But this is the removal of the tower. The representation has been made, that has not been considered, lordship.
Who is for the state?
But now, lordship, the district magistrate, my lord, since the district magistrate, my lord, does not report particularly to any principal secretary, lordship, or under any particular principal secretary, lordship, I have, my lord, served notice to the district magistrate directly, and it has been received, my lord. It is delivered.
My lord, I'll take instructions. Possibly what my learned friend has submitted, possibly the district magistrate will be operating as the authorized officer or authority under a particular statute. But
Yes,
still,
yes.
my lord, since the
18,
GM is
section
list-
18. Section 18, lordship, leaving section 18(2).
Section 18 of?
Of the Telecommunication Act. 18(2) is regarding compensation with the district judge. I am not on that. But
You are
other
only with
than
the
that,
removal.
any other dispute, district magistrate is the authority.
Shall have the exclusive resolve the disputes.
Including removal that your lordship will get from section 16. Removal, alteration, allocation, your lordship will get from section 16.
My lord, we can take instructions from the district magistrate, my lord. If my learned friend gives us a copy, my lord, informally, because we do not have a copy.
My lord,
Because we are not a party, so we're not,
no,
I'm not saying
since
that.
my
No,
lord,
district magistrate is a party.
Yes.
yes,
So if
my
I-
lord, and he is the, my lord, authority, my lord, who is not under any particular principal secretary, then, my lord.
I understand, my lord, but the district magistrate usually will be represented through us. Even in the, what I understand, even in cases where the district magistrate is an officer under a particular statute. So if my learned friend, my lord, kindly gives one copy to us, we will, my lord, take instructions, and whatever is needed to be done, we will do, my lord.
My lord, I am
And
seeking
where is your
simply an
affidavit?
order of consideration upon the district magistrate since he is
No,
the
let
authority.
him take an instruction.
Lordship.
What is the?
Kindly keeps it on Tuesday as per your lordship's convenience, my lord.
Not Tuesday, on Friday.
No, lordship.
Friday, Friday,
This
very well, my
Friday,
lord.
lordship.
Yes,
Yes.
This Friday, you
This-
give the affidavit of service?
Yes,
GTL has been served.
served and delivered. All
Affidavit of
delivered,
service
Lordship.
filed on behalf of the petitioner is taken on record. By the present writ petition, the petitioner seeks for the removal of the mobile tower installed by.
My lord, initially it was installed, the execution, deed execution between MS Dishnet Wireless, which subsequently take over by the GTL.
Okay. Installed by BISNet
The Lordship will get the page 17 is the deed of license. The Messrs Dishnet Wireless Limited. Page 17.
Messr Dishnet, DISHNET Wireless Limited, which has been subsequently taken over by GTL Infrastructure Limited, being respondent numbers 5 and 6. So and so, learned advocate, representing the petitioner, submits that the mobile tower has been installed in the land of the petitioner. The license of such mobile installation of the mobile tower has already expired in the year 2018.
2020.
2020.
Yes, Your Lordship.
2020. The petitioner made representation before the district magistrate to remove such mobile tower from her land. But in terms of section 18 of the Telecommunication Act 2023. Para, Mr. Kunaljit Bhattacharya, learned additional government pleader, seeks accommodation to take instruction.
At a copy.
I'm not recording, you give a copy of that.
Yes,
Yes,
that,
yes,
and that,
will serve, Lordship.
This matter on Friday. Friday, not 12th. 12th.
My lord, Hartin, my lord, I'm seeking 1 day accommodation. This is an application for compassionate appointment. My lord, West Bengal WBSCDCL is the authority, my lord. The reason for which, my lord, the petitioner has been the prayer of the petitioner has been rejected is that the petitioner is overrated. Now, my lord, in compassionate appointment for Group D post, my lord, the age is no bar. My lord, I am, my lord, guided by the 26 EMP of the my lord, government of West Bengal, my lord, where, my lord, there is nothing regarding overage in respect of the Group D employment under the compassionate ground. Now, my lord, they are saying that their rule doesn't permit. My lord, they never said, my lord, of what rule, my lord. Rather, my lord, they have a policy of 2023. Although, my lord, I am not guided by 2023 because my mother has been died prior to 2023. Even that 2023 policy, there is nothing with regard to the overage.
Okay.
Sir, we have not received the instruction yet, so kindly take it up on Monday.
My lord, I will bring their notification, their policy as well as the 26 EMP, which is, my lord, which will be guided in my case.
Okay. You'll take instruction or file a report on that day? You'll file a report?
If so, my lord, I will file an exception, my lord.
No, let them file the
Let them
report.
file the report.
If you go through the report, if
Yes.
you find that any such of objection has to be
Okay,
made,
yes,
then you seek
yes,
for
yes.
liberty to file exception.
Yes, yes.
Give the affidavit of service.
Yes, your lord.
Affidavit of service filed
Here
on behalf.
also, my lord, all delivered.
Petitioner is taken on record. By the present writ petition, the petitioner seeks for setting aside under cancellation of the order dated 26th August 2025 issued by senior manager within bracket HR and capital A, comma, ES and ER dash Roman 2 cell West Bengal State Electricity Distribution Company Limited within bracket in short WBSCDCL, rejecting the prayer of the petitioner. Page number?
Page number 41, P8, last page, lordship, the rejection order.
Rejecting the prayer of the petitioner for appointment on compassionate ground. Mr. Anirban Banerjee, learned advocate, appearing for WBACDCL, seeks accommodation to file a report. Let such report be filed by the returnable date. Advance copy be served upon the learned advocate for the petitioner. List this matter on which date? Mr.
Monday.
Monday, on 15th. 15th June.
Lordship, the service is not completed.
The advocate for the petitioner seeks accommodation to serve upon. State is there, which are the private respondents.
Private respondents.
Seeks accommodation to serve upon the private response of 4-2-12. State is represented. Please this matter before the next available circuit bench.
Lodge.
My lord, I'm appearing for the petitioner. My lord, this is a inter-district transfer application, your lordship.
Yesterday, my lord, I had received the brief, my lord. Kindly allow me, my lord, kindly make it, my lord, not this week paying, my lord.
You have not received the instruction?
My lord,
Yes,
my
your
lord,
lord.
board is the answering respondent. My lord, board is there.
I am the board, my lord. I am led by Mr. Diploma to board. Yes.
My lord, petitioner is seeking transfer in the district of Jalpaiguri to the, my lord, Howrah, DPSC, your lordship. My lord, representation dated 6/4/2026. My lord, kindly see page number 45, my lord. And on medical ground, gynecological disorder, your lordship. And medical and distance ground, your lordship.
Yes. Perfect. Let the representative consider that. When did you join?
My lord, joining is 22/7/2021. Page number, your lordship, 15/17, your lordship.
Letter
15
of
to 17.
confirmation?
Confirmation, your lordship, 22nd/7/2023.
15.
Page number 17, your lordship.
17.
Yes. Page number 17 is confirmation.
Serial number?
Serial number, my lord, 11. Laboni Das.
Ashun. Affidavit of service filed on behalf of the petitioner is taken on record. By the present writ petition, the petitioner seeks for direction upon the respondent authorities for grant of inter-district transfer from district of Jalpaiguri to district of Howrah on medical ground. The petitioner contains that she joined as an assistant teacher in Batabari BF Primary School, District Jalpaiguri on 22nd July 2021. The petitioner is confirmed in service with effect from 21st.
Page number 17, your lordship, confirmation.
23rd July 2023. No, 22nd, sorry, Guru.
22nd, your
July.
lordship.
22nd July 2023. The petitioner is suffering from serious gynecological problems on which date you made an application? On 6th April 2026,
6th April
the petitioner made a
2026.
representation before the concerned authority seeking transfer. However, the same is still pending consideration, hence this writ petition. Mr. Ensol, learned advocate for the petitioner, submits that the representation of the petitioner be relegated to the appropriate authority for due consideration. Learned advocate for the board as well as the state respondents leaves the matter to the discretion of the court. আচ্ছা ওখানে না অ্যাপ্লিকেশনটা করেছে অন মেডিকেল গ্রাউন্ড পলিটিক্যাল সাবমিশনে বললাম ফ্যাক্টে একটা বললাম সি মেড অ্যান অ্যাপ্লিকেশন 6 April 2026 সিকিং ট্রান্সফার বিফোর দি কনসার্ন অথরিটি অন মেডিকেল গ্রাউন্ড in view of the above submissions gynecological disorder बोला ना and is also undergoing psychiatric consultation. for the reason of acute depression. In view of the above submissions, the Secretary, West Bengal Board of Primary Education, is directed to
Board, my lord, respondent number 3.
is directed to consider the representation of the petitioner dated 6th April 2026 in accordance with law upon notice to the petitioner and dispose of the same by passing a reasoned order within a period of 6 weeks from date of communication of this order. Respondent number 3 is granted liberty to seek for medical examination of the petitioner prior to consideration of the representation of the petitioner. Learned advocate for the petitioner directed to communicate this order. All connected applications disposed of.
Affidavit, sir. নাম আলাদা করে দিয়ে দিন। নামটা কি আলাদা করে দিয়ে দিন? বলছি।
Item 17.
না না
I should kindly fix the matter next circuit because I'm led by Mr. Ronit Kumar Jha. He's out of station for his
You are for?
petitioner.
What is this matter?
I'm not acquainted with this fact. Actually, I've been instructed from the learned advocate on record. He's out of station for treatment.
Mr. So learned advocate informs the court that the advocate, he is advocate on record, Ronit,
Advocate on record is Ronit Kumar Jha.
who has gone out for medical treatment.
Ronit Kumar Jha has gone for medical treatment.
The advocate on record for the petitioner, Mr. Ronit Kumar Jha, is out of station for his medical treatment. He seeks accommodation. He seeks for fixing the matter before the next available circuit bench. In view of such submissions, release this matter before the next.
I'm grateful, my lord.
Yes.
My lords. Oh, 18 already.
None appears on behalf of the petitioner, nor any
State
accommodation,
is appearing, lordship.
nor any accommodation is sought for. State is represented for ends of justice. The matter is adjourned. কিসের ব্যাপার দিদি?
এখানে কিন্তু লোক থাকে। তুমি পাবে। এই এখানে কি হওয়া তো?
না হয়নি হয়
1819 কি হলো? 1819 কি হলো?
দ্বিতীয় ম্যাটার
ও এই দাঁড়িয়ে করে অ্যাপ্লিকেশন দিব তো অ্যাপ্লিকেশন দিতে হবে 1819 অ্যাপ্লিকেশন দিতে হবে
ডেট সিক্রেট
Yes, still.
My lord.
23, huh?
Kindly take it up tomorrow because here in the covering letter, my lord, it has been stated that it will appear on 11th before your lordship. So we are not ready with instructions. We have asked for the concerned department.
Lordship, I mentioned this matter on Monday itself, Lordship. Before Lordship, the thing is that if your Lordship takes the annexures, if your Lordship kindly comes to page now, annexure P3, the main matters relating to encroachment upon the PWD highways, highway act. Now this entire proceedings has been initiated pursuant to the order of Honorable High Court. But I found that in that order, in the petition, I was not the party in the petition.
But they are unable to locate the file.
সোমবার আমি কোনো না ইনস্ট্রাকশন আসেনি
ভেঙে দেবো তো বলছে
তো ভাঙবে তো ভাঙবে
তো ভেঙে দিলাম তো
ইনস্ট্রাকশন নেই আমার কাছে
হ্যাঁ
কবে ফাইল করেছো এটা
প্রায় তো ইয়ে
8/6 তো সার্ভিস করেছো ভাই আমি কোথা থেকে
কনসার্ন ডিপার্টমেন্টে সব সার্ভিস হয়ে গেছে আগে
কি চেয়েছো you need to send instructions today. Very well. My lord kindly keeps it today. My lord, my learned junior has had a talk with the concerned authority. They are scheduled to send us the instructions by today. We will again pursue it, my lord. And since my learned friend is raising an apprehension of demolition, kindly takes it up tomorrow, my lord.
Not today.
That's it. We just ensure we get whatever it is good, bad, and different.
Matter 24, Milord, I am for the petition. Matter 24, I am for the petition.
Lordship.
Am I audible? Am I audible? But am I audible, Milord? But it is the second round of litigation. But previously, petitioner filed a writ application before this Honorable High Court, and Honorable Coordinate Bench passed an order on 4th of April 2025. That is in page 21. My lord, kindly turn page 22. The ordering part, page 22, is the third paragraph. My lord, got it? paragraph 3. My lord, kindly see, I am reading. In view thereof, the district inspector of school AC Siliguri, being the fifth respondent, is directed to consider the prayer of the petitioner for transfer after giving an opportunity of hearing of the petitioner and the school concerned. And if the district inspector finds that the petitioner is a single subject teacher, then appropriate steps shall be followed in accordance with law. In case it is found that the petitioner is not single teacher, then the district inspector of schools shall take necessary steps with regard to the prayer of the transfer. But this is the law. But this is the order, previous order. Now, my lord, kindly come the recent order that is in next page, page 23. My lord, it is, my lord, page 23. My lord, second paragraph. The president, I am reading, the president and headmistress of the school inform the district inspector of school, AC Siliguri, in the said hearing that at present there are 396 number of students and 38 numbers of teaching staff in the school. Out of 38 numbers of teaching, only Amar Chandra Bhomik and Dulal Pal, being the petitioner before your lordship, are in mathematics subject teacher. So admittedly, I am not a single subject teacher from their record. Amar Chandra Bhomik is a normal section teacher and will be retired 2-3 years. So if the petitioner, who is the only mathematics teacher in this section, transfer, then it is almost impossible for the Amar Chandra Bhomik to take all math classes, checking all math papers, checking of math question papers at the time of examination. There is a science stream in the higher secondary section. Next, the petitioner Dulal Pal submitted some relevant papers and connection being judgment copy dated so and so. Shapun Kumar Singh of the state of India, he is also informed that he had applied for transfer through Utsosri previous, but his application was rejected. He also added he is not a single subject teacher. Next paragraph is important. The district inspector of school AC Siliguri stated that teacher transfer portal Utsosri is now under suspension. As the subject is mathematics and due to lack of teacher in some same subject, the matter will be sent to the higher authority for necessary suggestion according to the law, which is the hearing of the concluding. So, my lord, it is evident I am not a single teacher. And my lord, pupil teacher ratio, those they have mentioned 796 number of students in respect of 38 number of teacher. So, my lord, it is under the PTR is under the prescribed norm as per the, my lord, Right to Education Act 40:1. And by important fact, my lord, DI himself admitted he shall forward the matter to the next level, that is commission. However, I have inquired that no document has forwarded to the West Bengal Central School Service. But DI himself admitted their stand that it will needs to forward to the next higher authority. That next higher authority is the Central School Service Commission. However, the DI is sitting tight. So I am before your lordship. So let the matter DI forward to the commission. Commission take appropriate action. That is my submission.
Lordship, I am for the state, my lords. I do not hold any instruction as of now. My lords, kindly fix it on Friday. I will bring the instructions.
Great. No issue. Right. Better instruction is required.
So, sir, nothing. School has nothing to do.
Nothing to
Now
do.
the district inspector of schools, he has to take a decision.
Then as my lords
I'm for the
please.
school.
You're for the school. Okay, final report.
DI also admitted the
Nothing
fact
to
it is required to forward to the higher authority. However, sitting tight.
By the present petition, the petitioner seeks for setting aside of order dated 22nd May 2025.
My lord, partially setting aside because my lord, partially setting aside because DI admitted that my lord, it needs to forward to the higher authority. My lord, I am also on that. I am also seeking, my lord, it needs to forward to the commission.
Subject to clarification by your lordship.
What you
my lord,
have-
as per my
What
understanding,
you
my
have,
lord,
My lord,
what
Yeah, my lord,
you have
absolutely
prayed
means,
for
my
in the
lord, the commission
petition
of
that
school
is being
education.
recorded. What you have stated in your prayer in the writ petition, that is being recorded. You have
Yes.
never said that it is part or full.
no.
You have stated
Yes,
for setting aside of the entire.
Yes. My lord, subject correction.
Sitting aside order dated 22nd May 20. VDA memo number 291 within bracket 3/G/S passed by District Inspector of Schools AC Siliguri being respondent number 5. Affidavit of ordination. Sir, Sudeep Pal Chaudhary, learned
Sudeep Ghosh
advocate for the
Chaudhary, Ghosh
petitioners.
Chaudhary. My lord,
Sorry,
Ghosh.
Sudeep Ghosh Chaudhary, learned advocate for the petitioner, submits that this is second round of litigation. In the earlier writ petition being WPA 704 of 2025, direction was issued for consideration. In the event the petitioner was not found to be a single teacher for consideration of the prayer of the petitioner for transfer. And indisputably, the petitioner is not a single teacher, as is evident from the impugned order. Ms. Radhika Agarwal, learned advocate appearing for state respondents, seeks accommodation to take instruction. Will filing any report, or you will just take an instruction?
My lord, just I'll take instructions and come back.
Release this matter on Friday? On Friday.
Grateful.
Where for this?
School is represented. Give your name. Yes.
25.
My lord, 25, I am for the petitioner. My lord, petitioner is an assistant teacher in my lord secondary level of school. My lord, petitioner at the time of operating on Utsusri portal, petitioner several occasions applied in the online platform that is in Utsusri. That your lordship may kindly turn page 16 once, my lord. Page 16. My lord, petitioner made four times her transfer application on general ground. My lord, kindly see that rejection order all the times, my lord, school authority rejected my transfer application without applying any mind. My lord, first application, my lord, from bottom to top, my lord, 2nd August 2021, serial number 8, HY2 applicant error. Next application, my lord, 18th August 2021, applicant to HY, my lord, 18th August 2021, it is an error. Lastly, my lord, I am lastly on 14th, my lord, serial number 2, 14th of January 2022. Now rejection, 2nd of February 2022, low score. My lord, I am putting this question as per transfer rule. There is no embargo respect of low score. My lord, there are 3 types of embargo in respect of general transfer. First, my lord, single subject teacher. If I am a single subject teacher, there is a separate law how to tackle this situation. And secondly, my lord, 10% rule. If 10%, as per 10% rule means, suppose 20 teacher in the school, as per 10% rule, 2 teacher, 10% ratio, 2 teachers are eligible as per seniority for getting NOC. And thirdly, my lord, pupil teacher ratio. My lord, how, my lord, this low score, I fail to understand what is the meaning of low score. So I am aggrieved by that. Be that as it may, since long time has passed, my lord, petitioner is praying, my lord, relief, my lord. I am praying, my lord, similar situation, honorable coordinate bench passed an order that is in page number 17, similar identical issue. Here, my lord, liberty has given to the petitioner to file a face application and which needs to be considered by the school, then DI, then SSC. My lord, I am praying for similar relief. I am claiming the parity in respect with my lord Rajiv De. I have annexed, which is annexed in your lordship's brief, my lord, page number record, page 70. So this situation, my lord, without any justification, justified, my lord, reason, my lord, school authority rejected the same. And since long term has lapsed, my lord, several facts and circumstances has changed. I am only praying, my lord, similar to Rajiv De, my lord, kindly passed and similar order, give me liberty to file a fresh offline transfer application in general ground, which needs to be considered by the school. Then, my lord, DI, then SSC. My lord, it has lastly, last paragraph, it has been observed by the honorable coordinate bench in view of the petitioner is granted liberty to file application seeking transfer ground of distance. Report the concerned authority offline mode, prescribed format, rule 25, school authority shall forward the same to the DI, which shall forward to the commission. That relief by similar relief, my lord, I want.
Yes.
Since the rejection is of 2022, only liberty may be given to apply application.
Okay.
Petitioner has not yet even applied for transfer application. So further direction is not required.
No, he has to file an application afresh or
Afresh in prescribed format before the school authority. And school authority may be directed to consider the same in accordance with law.
Law and consequential steps be given in accordance with. If the
so why
petitioner
have
is
you sought for setting aside of that order?
My lord, setting aside, I am withdrawing, my lord, since that rejection is illegal, my lord, there is no justified ground. My lord, there is no ground embargo in respect of low score. I did not find Mr. Rai, I don't know Mr. Rai whether Mr. Rai find low score or not. My lord, three types of embargo in respect of just single subject teacher, 10% rule as per seniority, and my lord, pupil teacher ratio. My lord, low score, I don't fail to understand what is low score error. This
School
remark
service
is.
commission can reject on the ground of low score. School service commission can reject on the ground of low score, my lord, but not the
Yes,
school authority.
school service commission can do if, my lord,
No,
suppose I
this
have applied.
page 16, this has been filled in by the school authority.
Yes, school cannot.
Yes, ma'am.
School cannot. My lord, suppose, my lord, I have applied school A, another candidate also applied in school A. If my score is lower
Yeah.
than another candidate, then my lord, school service commission can reject that your score is lower than that candidate, so you can wait. But school cannot. School cannot.
Okay. Yes, who is for the state?
Yes, yes. Since Lordship, he has not applied a fresh Lordship, if they will apply Lordship, then it can be considered Lordship.
Okay.
Even the order which he has annexed in case number 17. Third paragraph. In view of the above, the petitioner is granted liberty to file an application seeking transfer on the ground of distance before the concerned authority in the offline mode.
But in that order, my lord, in page 18, the direction of the court is that the school authority shall forward the same to the DI. My lord, the rule, the school has the discretion to, my lord, consider the same, my lord. If, my lord, against any teacher, my lord, there are disciplinary proceedings or criminal proceedings is pending, my lord, then school will not issue the NOC, not forward. So, my lord, this shall, what your lordships kindly, my lord.
If otherwise eligible, if otherwise eligible, if otherwise eligible, kindly, if otherwise.
They will consider if found eligible, will
Yes,
forward.
yes.
Yes.
Same to the DI
Yes.
and DI to SS.
Not any mandatory direction, so that.
No.
Samjha.
Affidavit of service filed on behalf of the petitioner is taken on record. By the present writ petition, the petitioner seeks for setting aside of the illegal order of rejection dated for setting aside of the order dated 2nd February 2022 issued by the school authority rejecting the prayer of the petitioner seeking transfer. Vide application dated 14 January 2022 in the Utsosri portal. The petitioner contains that he joined as an assistant teacher in, when did you join?
But I have joined, just a minute.
27 July 2011
Yes.
in
27.
Botewadi Sitanath High School, Mekhliganj district, Bihar. The service of the petitioner was approved on 5th September 2011.
Yes.
Subsequently, A retention memo was also issued in favor of the petitioner on 29 December 2014. The petitioner's residence is situated about 101 kilometers from his present place of posting. The petitioner is suffering from several medical issues. Previously, the petitioners made several applications online seeking transfer.
On the ground of distance.
However, on the ground of distance, however, the same has been turned down on ground of error and or low score. And lastly, it has been a low score. Stop. Hence this, being agreed by such action of the respondent authorities, the petitioner has preferred the present writ petition. Mr. Sudeep Ghosh Chaudhary, learned advocate appearing for the petitioner, submits that the last rejection order of the school authority has been made with the remarks low score. However, there is no such provision under the rules to reject the application on the ground of low score. Be that as it may, he does not trace for setting aside of such order, but seeks that liberty be granted to the petitioner to submit a fresh application seeking transfer offline,
On general
which
ground.
shall be decided
On general
on
ground.
general ground, which shall be considered by the school authority in accordance with law. Mr. Sunit Kumar Roy, learned advocate appearing for West Bengal Central School Commission, concedes to such submissions. Acha, Mr. Chaudhary, to buttress his contention, full stop, the reliance is placed on the decision of a coordinate bench of this court in Rajiv Dev versus State of West Bengal, re WPA 539 of 2025. Ms. Supriya Singh, learned advocate appearing for state, respondent submits that in the event such application is made, the authorities shall consider in accordance with law. In view of such submissions, the petitioner is granted liberty to file an application seeking transfer on ground of distance before the school authority in offline mode within a period of 4 weeks from date. In the event such application is made in the prescribed format, the school authority shall consider the same, and in the event if found eligible, shall forward the same to the district inspector of schools, which AC.
Yes, AC.
Which respondent?
But AC, respondent number 4 possibly.
5.
Respondent number 5. 5.
ওইটা না করুন, একটা করুন যে shall take all consequential steps. If found eligible, shall take all consequential steps in accordance with law within a period of 6 weeks from date of communication of this order.
But kindly observe that, my lord, I am seeing Rajiv Dey is relying, since Rajiv Dey, your lordship quoted.
No,
Rajiv Dey.
I have given that consequential steps. That is what the school has to take. Now
My
the
lord,
DI will decide.
in
if
terms,
it is
my lord,
eligible.
only one line.
No,
my lord,
no.
In terms of Rajiv Dey. In
No.
terms of Rajiv Dey.
No, not in terms of Rajiv.
In terms of Rajiv
Only the
Dey,
school
my lord.
authority will take consequential
In
steps.
terms of Rajiv Dey,
If you are
decide
found
the issue in
eligible,
terms of
they
Rajiv
will-
Dey.
No.
Lordship.
6 weeks from date of communication of this order, learned advocate. Submission of. It will be 6 weeks from date of submission of your representation.
Lordship.
26.
26, my lord, I am for the petitioner, my lord. It is almost similar issue in with my lord with item number 25. My lord, I have applied for transfer on general ground in the year 2022. My lord, kindly turn page number 15. Page number 15, my lord. It is the Ushusri extract. My lord, lastly, I have serial number 2. Kindly see serial number 2. Lastly, I have applied on 22nd of March 2022. 22nd of March 2022, I have applied. On 17th of June 2022, the school authority rejected my application on the ground of, my lord, 10%. I have not come within the limit of 10% as per seniority. My lord, then, my lord, it is my case. Subsequently, staff strength of the school, it has happened in 2022, and we are now here 2026. Staff strength of the school has changed and augmented. So, my lord, by similar fashion, my lord, kindly, I am praying, give me liberty to file a fresh application since Utsoshri portal is not now in inoperative portion, in offline mode, distance round, and same shall be considered in accordance with law by the school authority. And if I otherwise eligible, shall process my transfer application in accordance. So that is my respectful submission.
No, why this was rejected in 22?
Basis of
You are
10%,
not
my lord,
on-
I have not within the 10% limit as per the seniority of the total teaching strength. Suppose I have stated, my lord, subsequently, my lord, subsequently
correct.
staff strength, 2022, staff strength has changed, my lord. Now, my lord, if a fresh application be considered as per staff strength, my lord, school ought to decide the issue basis of staff strength, 10%, my 10% law will be calculated, rule will be calculated. So everything,
Okay.
2024 to 2026, 4 years lapse. So give me liberty to file a fresh application. The school will consider in accordance with law. And if I otherwise eligible, shall forward the same, shall take all consequences.
Kindly come to page number 4, my paragraph number 7.
For paragraph number
Paragraph number 7.
7.
The rejection ground, they have only stated the ground, that copy has not been annexed. And the overall status has been only been given.
No, that is page 15 is the rejection.
Yes,
Kindly
yes,
come
page
to
15.
Page number 4. Let me complete. Like page number 4, paragraph number 6, 7.
Yes.
May I read it?
First
That
time.
making interact, it was rejected. That copy has not been annexed.
However, on 3rd, school authority rejected
ground
the
it is
application of
rejected?
petitioner.
My lord, it is
Sir, I have
reflected,
taken-
my lord, it is reflected in the rejection order remarks portion. Kindly see, sir, kindly see remarks portion.
Page 15, Mr.
Page
Ghosh,
15.
page 16.
Page 15.
15.
Kindly see page 15.
Page 15, column
Yes.
number 3.
Column number 1, my lord. You are not calling
No,
me
column number 3.
1, 1.
1. My lord, it is
Column
bottom
number
to up.
3.
My lord, it is bottom to up.
Column number 3.
Yes.
He is referring to your rejection dated 3rd September 2021, which is
Yes.
reflected in column number 3.
Yes. It is also 10%. It has been observed. It is also, my lord, you are not, I am reading. My lord, column number 3, you are not eligible for transfer. You are not eligible for transfer. You are not falling within 10% of seniority. Most test transfer application teacher is the school. My lord, it is 10%. Subsequently, again, I have applied. There is no bar to making further application. 22nd March 2022, column number 2. 22nd March 2022, again I have applied.
He has
And
made
my
several
lord-
applications.
My lord,
Yes, Mr. Ghosh.
Yes, Lord, I have taken instruction, Lord, that there is serious issue with ratio between the pupil and the teacher. 146 to 1. This should be 127, 1. Parent pupil is the ratio. According to my taken the education RT Act 2009. It was serious issue.
now my lord, it is new ground. It is new
I
ground.
have taken instruction, Lord.
Previously rejection on 10%. So let the school will come. Let school authority ultimate authority to decide the pupil teacher ratio. School authority is decide. That I want.
I am objecting on the ground of delay. If your lordships kindly look into the date of rejection, it's 17th of June 2022. petitioner is approaching the High Court in the June 2026, after 4 years. In
Yes.
this matter, my lord, your lordship can only give liberty to the petitioner to apply after it.
Yes, that I am praying and consider the same in accordance with law. That more, that is that, and my lord, by respectful submission with kind sanction of my
After
lord,
4
my
years,
lord, my state
challenge.
advocate, my lord, pupil teacher ratio will decide by the school, not by the DI. And it is a new ground.
I have taken instruction of school also. This is the guideline. This is the guideline. This petition should be taken.
Yes, well, that is come, my lord, I shall have the remedy. If that new ground will, if new ground, my lord, I have the right to dispute such contention. I have the right, my lord. So if school will come and order that your application, if I make any application and school will reject the same, it's a new ground that pupil teacher ratio will adverse. I will take the recourse. I will take care of that. But since my 10% ground, previous rejection on 10% ground, I am on that. If new ground arises, they will come a proper order. I will take the recourse. It is not that I have the right to defend that. Mere submission a report is not, my lord, suffice. My lord, my prayer, since my lord previous rejection on 10% application is barred by the pupil teacher ratio, I will take the recourse. I will take the recourse.
No, it was rejected in the year 2022, my lord. Subsequently, my lord, they have come in the year 2026. Like, if the new ground arises, if the new ground applies, they should have applied the
Yes, that I am saying.
That I am saying. After filing this
That is what he is seeking
after
for, a
filing
liberty
this
to file an
petition, we are taking
application.
liberty of this court, my lord.
Uh,
Why the leave is required?
Why not? Now
I
the
asked
now
myself,
scheme is suspended, sir. And again, my lord, my new ground, it is a pupil
They
teacher
can-
ratio is a new ground. I am not aware with that. Previous rejection on 10% ground. Now it is on pupil teacher ratio.
Okay.
It will come in
The
the
one they
proper
can
proper order.
liberty is not required, my lord. The under the cartel of liberty, my lord.
No. If a liberty is granted to him and the school will consider his application
Sir,
bearing
that liberty is not-
in mind the pupil teacher ratio.
Very
Yes,
good.
that
That I want.
that liberty is not required from this court, my lord, from
Why?
this honorable court. That they can apply anytime.
My lord,
Without-
I am aggrieved by the previous
Without the
rejection.
liberty, my lord.
I am aggrieved by previous rejection. By 10%.
2022.
By the present writ petition, the petitioner seeks for no, in that event, this will be dismissed because consistently there is a view that you are not within the 10% of the senior
My
most
lord,
teachers
staff
to be
strength
considered for
has
transfer.
changed. My lord, staff strength has changed. Now
Hmm.
staff strength has now it has when
That
it was
you can
decided
say.
present
my lord,
present
that
staff
my lord,
strength basis of
that is
present
Six
staff
for-
strength 10%
my lord.
will be decided.
Let them make a flex application without leave of this.
ওইটাতে না একটা করবেন যে this court has not gone into the merits. By the present writ petition, affidavit of service filed on behalf of the petitioner is taken on record. By the present writ petition, the petitioner seeks for setting aside of the order dated 17 June 2022 issued by the school authority rejecting the prayer of the petitioner seeking transfer dated 22nd March 2022. The petitioner contains that. What is the ground?
Well, 10%. I am not within the 10% as
No,
per
no.
seniority.
What is the ground of your
Distance
transfer?
ground. Well,
Gender-
distance ground. Medical ground, there is no embargo.
By
All
the
will
present
flow.
writ, the petitioner contains that. The petitioner contains that he joined as an assistant teacher
According to our permission, 28 kilometers.
28.
Yes, Lord.
Joined Bara Maricha Deval Hussain High School HS, District Kuch Bihar on 30th August 2010. The petitioner is approved in service on 18th November 2010. And a retention order has been passed on 21st. Retention memo has been issued on 21st January 2016. The petitioner's residence is situated about 30 kilometers from his present place of posting. Previously, the petitioner applied for transfer on the ground of distance. However, the same has been rejected, observing that the petitioner is not falling within 10% of total teaching strength.
As per seniority.
As per seniority. Hence this writ petition. Mr. Sudeep Ghosh Chaudhary, learned advocate for the petitioner, submits that with the passage of time, the staff strength has changed. And as such, he seeks liberty to file a fresh application offline seeking transfer. Mr. Shunit Kumar Roy, learned advocate representing respondent West Bengal Central School Service Commission, concedes to the same. Mr. Urijit Ghosh, learned advocate for the state respondents, submits that the petitioner does not require any liberty of the court to file a fresh application. He submits that there is acute shortage of teachers. He is chemistry teacher.
Yes, sir. Yes, Your Lordship.
In subject chemistry in the said school. On transfer of the petitioner, there will be the pupil teacher ratio within bracket PTR will be affected hugely affected. He files report of the District Inspector of Schools AC Kuch Bihar dated 10 June 2026, which is taken on record. As far as the arguments advanced on behalf of the state respondents is concerned, it is for the school authority. In the event the application is made by the petitioner seeking transfer, it is left open to the school authority to consider the aspects as per rules, bearing in mind the pupil-teacher ratio. However, that cannot be a bar in granting a liberty to the petitioner to approach seeking transfer. In view of the above, the rest is within 4 weeks you file an application and it will be decided by the school authority will consider in accordance with law, keeping in mind the pupil-teacher ratio, and if found eligible, shall take all consequential steps in accordance with law. Within a period of 6 weeks from date of submission of the application.
All other apart from PTR issue, all other ground.
All other including PTR. All the aspects is to be taken into consideration, and if found eligible, then we will decide. Rest again. Next.
I am for the petitioner, my lord. 27, I am for the petitioner. My lord, previously, my my lord, 2021, my lord, petitioner applied for transfer. It's a secondary level transfer in the secondary level school. My lord, petitioner applied for his transfer, for her transfer on distance ground. My lord, however, my lord, school authority returned it on the peculiar circumstances. My lord, kindly see page 17 once. My lord,
State who is
My
appealing.
lords, I am for the state. My lords, no instruction has been received by us.
For the commission.
So we may
Take
need to this
instruction.
time.
In this matter also.
yes, fresh, I am seeking, my lord, fresh application. My lord, I am seeking fresh application to be
Is
filed, my lord.
operational to address less than 25
Yes, my lord,
kilometers.
kindly see, my lord, my lord, kindly see page 16. My lord, distance proof is 61. Distance proof saying 61. On oath, I have stated the distance from the present school to residence is 16. Moreover, my lord, rule says, my lord, distance from present school to where I seek transfer, that should not be less than 25. Rule 3 of the transfer rule says, my lord, it is school to school. There are several judgments in the honorable coordinate bench, my lord. My lord, there is no, my lord, measurement is not from the residence to school. It is from the present school to opted school where I willing to go. That school should not be less than 25. That must be beyond 25. My lord, that is the law. My lord, even my lord, I am giving me liberty to file a fresh application. I have annexed the relevant document, page 61. Page 16, my lord, distance from present school to residential address is 61. I have averted it in my writ application. So give me liberty to file a fresh application since it was 2021 and matter can be disposed of.
No, the rejection is on the ground that the distance between the present school and the distance where you preferred is less than 25 kilometers.
Yes,
That
my
is
lord,
what has been written.
Yes,
No, my lord, no,
my lord,
Distance
I am
from the
telling.
present school to present address.
Parents' address.
It should.
It should not be.
Less than 25 kilometer and not included in 10%.
10%. So
School has taken
10%
two
is, my
rounds.
lord, staff strength has changed, my lord. 2021, now 2026. And my lord, another thing is distance is not relevant from present school to
Okay, you
residential address.
take instruction and come back
Lords,
on Friday.
Friday.
Affidavit service filed on behalf of the petitioner is taken on record by the present writ petition. The petitioner seeks for setting aside of the order dated 16th August 2021 issued by the school authority rejecting the prayer of transfer made by the petitioner with a application dated 2nd August 2021. Mr. Sudeep Ghosh Chaudhary, learned advocate for the petitioner, submits that the application of the petitioner was rejected on frivolous grounds. Ms. Radhika Agarwal, learned advocate for the state respondent, seeks accommodation to take proper instructions. Place this matter on Friday, 12 June.
Grateful.
Yes.
28, I am for the petitioner, my lord. My lord, it is the second round of litigation, my lord. Previous order, my lord. Coordinate bench order is page 26, my lord. Kindly see page 26 once. Page 26, my lord. My offline transfer application was pending before the school authority. Honorable coordinate bench directed to consider the same in accordance with law and passed a recent order. My lord, paragraph 6, page 27, the direction in view of the instant repetitions and disposal by directing head of the institution consider the same in accordance with the prevailing transfer rule, and if prayer of the petition is allowed, then necessary steps of forwarding application to the district in accordance with law, the earliest but positively the period of 8 weeks from the date of communication this order. My lord, based on that order, my lord, the recent order passed by the school authorities, page 29. My lord, that ground is, my lord, I am an assistant teacher in the, my lord, I am the assistant teacher in the physical education subject. I am the only teacher in the physical education subject. My lord, now school authority, my lord, that means I am a single teacher in physical education subject. My lord, page 29. My lord, that is, my lord, school authority has no right to reject my transfer application in respect of single subject teacher. I am relying the rule 9 AC, which was issued by the West Bengal Government Principal Secretary, 3rd January 2021. Kindly, Mr. Loskar is handing over. Kindly, Mr. Loskar, hand over the relevant rule. In that rule, it has stated in case of single subject teacher, if any incumbent applied, school authority shall not reject the same and forward it to a DI. And DI shall make endeavor to
Which rule?
find out an alternative arrangement from the neighboring school, and if then forward to the secretary. But division, honorable division bench in Rupak Dua's judgment, it has been clarified by the honorable division bench Rupak
If
Dua's
it's single
judgment.
subject, teacher makes reject the application, giving inform such application. DI discuss the matter with CAC. Please take it.
May I read, my lord?
So give a legible copy. This is.
May I read? But in Rupak Dua's decision, it has been clarified, but it has recorded in the division bench order. I have handed over. Kindly see this judgment. Entire thing is clear. How to deal with the single teacher decision. My lord, the entire thing is clear. So school authority has no power to reject the same. They has to forward it to the DI. Our January notification says, my lord, in case of single subject teacher, school authority shall not reject the same and forward it to the DI. DI shall take all endeavor to find out alternative arrangement and forward the same to the School Service Commission. Now, under division bench says DI shall make effort to find out alternative arrangement only by 3 months. This is now settled, and honorable coordinate bench are following that. This is almost dictum. So, my lord, this impugned order is bad in the eye of the law. They has to forward to the DI.
Yes.
Lordship, I have not gone through this judgment, Lordship, even I'm not aware of the notification, Lordship. Fix it on Monday, Lordship. In the meantime, I will look into all the judgments and
In this
notification,
matter,
Kindly fix it Friday, my lord. Friday.
Lordship, Monday, Lordship.
in 3rd January 2022, my lord, 9 AC, it specifically provides for transfer of single teacher. It says that, my lord, school shall not reject the transfer application of any single teacher and hence immediately forward the same to the DI. And DI will, with the consultation with the CSC, Commissioner of Education, try to find out alternative arrangements. And if some arrangement is made then the respect of school shall forward the application to the School Service Commission for effecting the transfer order.
Okay.
Here, my lord, subsequently, some decree was also passed by the honorable division. And my lord, representation of the school is
Now, the affidavit of service filed on behalf of the petitioner is taken on record by the present writ petition. The petitioner seeks for setting aside of the order dated 21st April 2026, passed by teacher in charge, respondent number
Lord,
7
number.
of Hetampur Raj Girls High School, Dubrajpur district, Birbhum. How this is before this court?
My lord, it can be
Birbhum is-
possible. There is a precedent. My lord, if transfer application, they are seeking transfer from the one district to another district. Petitioner is residing in the jurisdiction of the circuit bench. So petitioner is eligible, but there are several precedent. Next day I can satisfy your lordship. And Mr. Rai is aware. Mr. Rai and other my learned friend is aware. It can be possible. In transfer application, it is involving the several district, one place to another place, it can be possible. Petitioner is residing, my lord, in the jurisdiction, seeking transfer, Jalpaiguri. My lord,
কি বলুন?
No, permanent district.
চাকরি করছে কোথায়?
Teacher in charge,
চাকরি বীরভূমে
district Birbhum. Respond number 7.
থাকে এখানে সার্ভিস প্লেস
Mr. Sudeep Bose Chaudhary, learned advocate for the petitioner, submits that the
জলপাইগুড়ি ডিস্ট্রিক্ট ইন্সপেক্টর জলপাইগুড়ি
that previously the petitioner filed a writ petition being WPA 355 of 2026, wherein direction was issued to the school authority to consider the application of the petitioner seeking transfer in accordance with the prevailing rules.
ডিআই বীরভূম হবে
The respond number 7, teacher in charge of the said school, has rejected
স্কুলটা দেখো বীরভূম
the prayer of the petitioner, which is dehones the prevailing rules. The rules clearly provides that in the event on the ground, is rejection on the ground that the petitioner is a single subject teacher. The rules clearly provides that in case of single subject teacher, the school authority will not reject the application, rather will inform the DIAC about such application, who in turn will discuss the matter with the CAC and make appropriate arrangement so that the application of seeking transfer can be processed. Ms. Supriya Singh, learned advocate for the state respondent, seeks accommodation to take proper instruction, resume on Monday.
మండే
On Monday.
Monday, problems, problems.
29.
You are the petitioner.
I'm appearing as a petitioner in person. Lord, under compelling circumstances, Lord, I had to appear, Lord, as a petitioner in person. Lord, the fact in brief is that, Lord, I, along with,
May I, my lord, just interrupt Dr. Chaudhary here? My lord, we had taken, my lord, all measures so that we can get the instructions, my lord, since Mr. Chaudhary is appearing in person. But unfortunately, my lord, we have not been able to get any instruction. Your lordship can kindly keep it on Tuesday, because we are trying to get my lord, from both the assistant registrar and registrar.
No, what is the matter?
Lord, matter in brief is that, Lord, I am a partner of a partnership firm of lawyers, Lord, a law firm. Lord, I, along with one of my colleagues, Lord, we have established a law firm. Now, Lord, the firm has to be registered, Lord, as per the provisions of the Indian Partnership Act. So, Lord, once I submit the application for registration of the firm, Lord, they return my application with, Lord, objection that the firm has to submit a trade license. Now, Lord, the first objection was trade license, along with some other objections were also there. So, Lord, I have cleared the other objections. But so far as the trade license is concerned, Lord, I had given a representation that trade license is not applicable on a firm of lawyers. For a law firm which is in the profession of the practice of law, they do not require a trade license. That is only for the business concerns who are into trade and business. For them, it is applicable. Lord, this is the issue in question. Now, Lord, I'll take your lordship directly to the application. Lord, it starts from page 53 onwards.
No, we will hear. This is the sum and substance.
Yes, yes.
And
When
I'll put, my lord, want the specific instruction, my lord, so that it can get resolved here only. Because as a lawyer, my lord, my personal belief, my lord, is that asking trade license from a lawyer is unjustified because we do not fall under the ambit of any trade as such.
Yes.
But why this particular, my lord, document has been asked for, that is the specific instruction we have sought, my lord. So yeah, if we can get it, I'll trying to get it by Tuesday. If your lordship gives it on Tuesday, my lord, I do not want it, this particular matter to my lord, to be kept pending.
B, you are pressing your prayer B.
Yes, my lord. My lord, the issue is totally on the question of law. So, my lord, it can be decided.
No,
there is
anyway,
no-
your lordship is a bit troubled with that ultra virus word.
Yes. Why
No,
you have
I
said
do
so?
not think he is asking, saying that anything is ultra virus that way. তুমি কি virus challenge করেছো কিছু?
No. My lord, I am saying that this insistence upon a trade
Yes, yes.
license from the lawyers is
It-
ultra virus to the provisions of
Or
the Act.
maybe dehorse the.
Yes, yes, that's
Because if it is some ultra virus challenge, then the learned advocate general has to.
Okay. Acha. Affidavit of service filed on behalf of the petitioner is
Affidavit of
taken on
service.
record.
affidavit of service.
Dr. Arjun Chaudhary in person submits that he applied for the registration of a partnership firm or where is the purpose given in the partnership deed? Purpose of the partnership?
Carry on the practice of profession of law.
Carry on the profession. You have mentioned that.
Yes,
Carry
yes,
on the profession of or carrying on professional practice of law.
But page 27.
Yes. Objections were raised by the authority concerned, which has already been removed. Save and accept submission of a trade license. For carrying on the professional activities of a lawyer through a law firm, no such trade license is necessary. Mr. Kunalji Bhattacharya, learned
One more
additional
thing,
government
Lord,
leader,
just that.
seeks accommodation to take proper instructions. When Friday?
Kindly keeps it on Tuesday, madam.
On Tuesday then.
Lord, one more thing I'll just add. Lord, even the Partnership Act 1932 does not require, my lord, of a trade license. As per section
trade
58.
license bowl, no? The Partnership Act also does not require for submission of a trade license for registration of partnership firm.
Yes. Great. I'm for the petition.
Item 30, my lord, item 30, my lord, I have the instruction to appear on behalf of the requisitionist, but no copy has been served upon any one of my clients.
You have a respondent number?
I am for the state respondent.
I am for the respondent requisition. Am I audible to your lordship?
Yes, it respondent. No.
Lord,
Private.
I have been informed or instructed to appear on behalf of all the requisitionist in the matter, being 9 in numbers.
They are not parties in them. The issue is very simple. They are not parties to the writ petition. The issue is regarding issuance of a notice of on motion of for removal of Pradhan by the concerned BDO, who is the precise.
Jahan is representing respondent number 7.
No, my lord,
No,
they
my lord,
are not parties.
we are the requisitionists who brought the motion, on the basis of whose motion, my
Okay.
lord, the prescribed authority has issued the notice. So if they don't make us a party, it's a defective petition. How could they move this? Section 12, my lord, section 12 says our notice of motion is to be signed by at least.
Kindly hears me out.
Then on the basis of
The
that,
issue
the
is
video
very
can
simple. Well, the issue is very simple. Malad, I am the elected Pradhan of the concerned Gram Panchayat.
Hmm.
Malad, I was elected in the West Bengal Panchayat elections 2023. And Malad, the members of the Panchayat who had been elected therein, they unanimously elected me as the Pradhan thereof by pursuant to a meeting which was held on the 11th of August 2023. Malad takes up page number 15 of my writ application. That is, those are the minutes of the meeting.
Yes.
Wherein all the elected members were present. They had signed the said minutes. And my lord, unanimously, I was elected unopposed as the Pradhan of the said concerned Gram Panchayat. Pursuant to election of myself as the Pradhan, I was
On which date?
my lord.
Date of election is?
My lord, this meeting was convened on 11th of August 2023. The West Bengal Panchayat elections 2023.
11th August.
Yes. Sabat Tariq. But pursuant to thereto, I was declared elected. My lord takes up the page number 22, my lord. This is the declaration of the result. I was elected uncontested as the Pradhan of the concerned Gram Panchayat, being the Gitaldaha 1 Gram Panchayat, which is under Dinhata block of the district of Kuch Bihar.
Mr. Jahan, we take the matter after the recess. Huh?
Yes,
If you Lord so desire.
Yes.
Good.
Panchayat Act.
My lords, as I was referring to page 22 of my writ application, wherein I was issued wherein declaration of result was granted in my favor. I had been elected to the office of the Pradhan in uncontested form. That takes up page number 22.
Yes.
This was pursuant to the meeting that was held beforehand. It was pursuant to the meeting that was held on 11th of August 2023. My lord, the notice was, this declaration was issued on the same day, that is the 11th of August 2023. My lord would find that date at the bottom left-hand side corner. And thereafter, I was performing my duties as a Pradhan of the said Gram Panchayat. However, all of a sudden, on 25th of May 2026, my lord would find the next page, that is page number 23. A representation was made by some of the elected members against me before the block development officer, who is the prescribed authority of the Gram Panchayat concerned. It takes up page number 23. This is a representation in the form of a no confidence against me.
Okay.
Page 23. This was received by the office of the block development officer and the prescribed authority, and pursuant to this representation that was made by about 9 members of the said Gram Panchayat, a notice was issued to me. That notice is annexed at page 26, my lord. This is the notice, this is the impugned notice which I have challenged in this writ petition. It takes up page number 26. This is the notice in form 1E of the act concerned. This is the notice wherein a meeting on motion for removal of the Pradhan was issued in my name, and the date was fixed on tomorrow, that is 11th of June 2026 at 2 p.m. But my contention is that this notice which has been issued by the concerned prescribed authority, that is the block development officer, is absolutely divorced the amended provision of the West Bengal Panchayat Act. But I have annexed the Kolkata Gazette. Well, it takes up the relevant provision that is at page 28 of my writ application. There is a subsection 12 of the West Bengal Panchayat Act, section 12. The subsection 12 earlier was, if I may read the earlier provision, prior to the amendment, there was a bar on issuing such notice within a period of 2.5 years from the date of the Pradhan and the Upa-Pradhan entering into office. Subsequently, by virtue of this amendment, this was extended to 3 years. Now, since I was elected as the Pradhan on the 11th of August 2023, so my 3 years completes on the 11th of August 2025. However, the meeting concerned has been convened on the 11th of June, that is 2 months earlier. That is why I have challenged this notice, which is at page 26.
Is on that page, madam.
Subsection 12 is the
Left-hand side of it.
previously it was 2.5 years.
Now it has changed to 3 years.
Now it has been, this is the latest amendment. This was introduced in the month of February 2026 in the West Bengal Legislative Assembly.
Where is it?
This was
Amended provision.
Well, that is at page 27 of my writ petition. Well, the Kolkata Gazette. Dated Saturday, February 7, 2026. And my lord, the next page, that is page number 28. Amendment to section 12 of the West Bengal Act 41 of 1973. Point number 2. For subsection 12 of section 12 of the West Bengal Panchayat Act 1973, hereinafter referred to as the Principal Act, the following subsection shall be substituted. Notwithstanding anything contained in subsection 1, no meeting for removal of the Pradhan or the Upa-Pradhan under this section shall be convened within a period of 3 years from the date of election of the Pradhan or the Upa-Pradhan, either at the first meeting following reconstitution of the Gram Panchayat or for filling casual vacancy in the said office.
Yes.
So this is the provision that I am amended provision that I am relying upon. Based on this provision, the notice, that is at page 26, that is the impugned notice that notice is bad in law by virtue of the fact that it has been issued prior to the completion of the period of 3 years.
My lord, this annexure at page 27, my lord, is the bill. My instruction is that this bill was never notified as an act. So the act remains as it is, my lord. It is the bill which was introduced. This bill was introduced, bill never got
Page
notified
27
as an
page
act.
27 says that this act may be called as West
This is the bill, my lord, which was presented. This bill was not notified. The governor's assent was not obtained. It was not notified as an amended act. So this is the bill, my lord. And here, if I may, my lord, rely on another thing, my lord. My learned co-counsel, my lord, had shown me, I'll show to my learned friend and also to your lordship, my lord, the website of the West Bengal Legislative Assembly, my lord. There, in the year 2026 till now, the number of bills which were presented is mentioned, and the number of acts according to the bills which were notified are also mentioned, my lord. I'll just show it to my learned friend and show it to your lordship also.
My lord, I am for the requisitionist to whom, my lord, I am led by Mr. Sarwar Jahan, and I am Mr. Gaurav Das.
Yes.
My lord,
Yes, Mr. Das.
my contention is that, my lord, the 12 notice of removal has been, my lord, due to our requisition. And my lord, we are the 9 members. My lord, without adding
Yes.
us a party, my lord, we are very much necessary parties. And my lord, I am fully supported the argument advanced by learned advocate state respondent. My lord, that bill is not been notified. And as the entire fact and circumstances, my lord, that has been done in accordance with law. My lord, we are the necessary party. This
I'll show it to my
petition
learned friend, my lord. This is, I'll show another page, my lord. Kindly see, these are the bills which have been introduced. The last one is the bill which my learned friend is referring to.
Yes.
May I, my lord, just, if your lordship is okay, may I just take it and I'll show one more page, my lord, to my learned friend and also to your lordship.
Asking the legislature.
No, the bill was introduced.
The report of the Indian Express.
My lord, the court is not visible.
Court is not visible.
My lord.
You will.
My lord,
Now you can see. Hey, কোডটা দেখাচ্ছে না। They say that there is a technical problem in your side. I mean the principal bench.
Oh,
এই
my
তো?
lord.
দেখো কথা বলো।
My lord, and this is the page of the West Bengal Legislative Assembly, which gives the details of the acts, my lord, which have been passed.
Before your lordship,
Now kindly seize, my
we
lord.
are the necessary parties. Kindly give us an opportunity to defend in this case and serve me a copy.
Kindly seize, my lord. Kindly seize that West Bengal Panchayat Act Amendment Act is not there. These are the acts, my lord.
It was just prior to the coming
No,
into
no.
force of the model code.
This is the latest status of the West Bengal Legislative Assembly.
But then, if it is before the model code of conduct, there is no
Yes, just
scope
immediately
for
prior,
having
because
it notified as an act.
Yes, the
Yes.
model code of conduct came into force, my lord. I'll be very fair in my submission. The model code of conduct came into force in the state of West Bengal from 15th March 2026. And this bill was introduced on the 7th of February 2026. And I have reports of some concern. I did not file find the original copy of the act.
Taken the form of an act.
It has not taken the form. The website of the West Bengal
I'll be very
Legislative
fair.
Assembly is there.
I'll be very fair in my submission. I have not found the
So,
copy of the original
amendment has
act.
not been
But the thing
incorporated
remains
as
that
yet.
it
Yes,
has been
my lord.
passed by the legislature. That is the
The
information
bill
that
was
I have.
introduced.
The bill was introduced and passed by the
Okay.
state legislature. It was in the place in the state legislature, and the same was passed. That is what information.
Even, my lord,
I'll be very
even
As
assuming,
on date, as it stands, is 2.5 years.
yes, my
that
lord.
was
As
the,
it stands today, it's 2.5
as it
years.
was, and this was introduced in February
So on such ground,
2026.
this cannot be.
This was the thing.
So,
And my lord,
2.5
regarding-
years, my lord, there is
and
no
my
information.
lord, regarding the submissions that had been made by my learned friend from
I
the
grant
other
you
side.
liberty, you
My lord,
to implead the requisitionist
my lord,
in the
I do
present
not have, I do not
petition
have
and
any,
serve a copy upon
I do
them.
not have any problem with them, my lord. My lord, my humble prayer would be to, at least for the time being, issue a limited stay on the same.
No, my lord.
There
No,
cannot be.
There cannot
only
be
for a
a-
limited period.
My lord, I opposing the
The
prayer, my
meeting is
lord.
on tomorrow. My lord,
My lord, what
otherwise
I
my
am
writ petition will
opposing
become
the prayer, my
infructuous.
lord.
By the
No
time
grounds has
I
been,
sub
no
them and
ground has
come
been
back.
taken.
Only a
My lord.
limited stay, by the time, otherwise my writ petition will become infructuous.
The only-
They are not likely
My
to
lord,
be prejudiced in any
no
manner.
prima
The
facie
only
case has
ground
been
of
made out
challenge
to
is
stall the
3 years, my lord,
meeting.
which your lordship has been seen, is 2.5 years as on date.
So on
Because
such
otherwise my
ground,
writ
the,
petition will become infructuous. Mother. That is the only,
on
only,
such ground, the notice which has been issued under
Yes.
Form 1E cannot be challenged.
that is
Grateful,
page
my lord.
26. my lord.
Page 26.
Page
Two
26.
and a
That is
half
the-
years is complete now. They can file
They
a
can, yes.
petition seeking for removal.
I believe, my lord, I'll make a fair submission. First of all, the objection that has been put forth by my learned colleague from the other side, who the persons who had made the original representation before the prescribed authority concerned, I do not have anything against them. I am willing to add them as a party. I'm willing to add them as a party in the instant writ petition. But for the limited period, at least for a limited period, as this
What would be
court,
the ground
honorable court thinks
to stay
appropriate.
the proceedings?
My
When,
lord, for
uh,
that limited
because
interim
this is
stay,
tomorrow,
my
that
lord,
is
they
the-
need a prima
Sir,
facie
when a
case.
requisition has been made under the Panchayat Act, there is a stipulated period
Lord.
within which Form 1E notice has to
Yes,
be given.
yes, yes, my
This
lord.
has been complied with by
Grateful.
the prescribed authority.
Yes, my lord.
Now we face the floor.
Now, my
Grateful,
lord,
yes, my lord.
my
That is
writ
it.
petition, my predicament
No,
will be
no,
that my
we are
writ
not
petition will
concerned with
become
that.
infructuous if tomorrow
The
the meeting.
submission was advanced as if 3 years is going to complete in the month of August.
Yes, it is
Correct.
as per the amended provision. It is.
But
my
that bill, he has shown that that has not taken the form of an act.
But I
So
am
as on
fairly
date,
I'm
it
also
is two
fairly
and a half
submitting.
years
my
that
lord.
is completed, so there is no bar in having a requisition and
I bow down to,
Proceeding
I bow down to
issue a
whatever,
notice.
I bow down to whatever has
So
fallen
you
from your
appear
lordship.
before on
Grateful, my
11
lord.
June to 5th.
Yes.
Yes, on 2 p.m. you
Grateful, my
appear.
lord.
Yes, grateful, my lord. That's it.
My lord, the only thing is that this there's a confusion whether this particular bill which was introduced before the state legislature has received the
There is no
assent of the
confusion,
governor.
my
or
lord.
not.
There is no
If my
confusion.
learned friend here says that it has not received the assent of the governor as of now, my lord, let that be indicated in the
Yes,
order.
yes,
Let
my
that
lord.
be
It is
recorded.
my submission on
Let that be
instruction.
recorded in the order that
Yes, my lord.
my learned friend from the state has
Yes.
submitted that he has not received the assent of the governor.
Yes.
And that
On
was-
instructions, I'm submitting that.
Mr. Das,
Yes, my lord.
Mr. Das, I am granting leave to the learned advocate on record for the petitioner to implead all the
My lord.
9.
My lord.
The requisionists as a necessary party, he will serve a
My
copy
lord.
upon you.
My lord.
Correct?
Grateful.
And you are
Grateful.
adopting the submission as advanced by learned additional government pleader.
Yes, my lord. And my lord, also,
Okay.
also on the point that we are the necessary party, so we have to make, and my lord, on the point of interim order, my lord, no prima facie case has been made out.
Okay.
Let the meeting be held.
Ashun.
Let him face the act of democracy. He loses his confidence, so he does not for a time being be seated in that chair. And let him face the consequences.
Okay. Where is your affidavit of service?
Not.
My lord, state is represented.
State is represented. I have already.
Affidavit of service filed on behalf of the petition is taken on record. By the present writ petition, the petitioner seeks for setting aside and or quashing of the impugned notice dated 1st June 2026 issued by the prescribed authority convening meeting for motion of removal of Pradhan of Gital Daho 1 Gram Panchayat under Dinhata 1 Development Block, Kuch Bihar. On the prayer of learned advocate for the petitioner, leave is granted to implead the requisitionist Where is the application that representation?
Well, the
Requisition.
requisition is application page number 23, my lord. Page number 23. 9 number of requisitions.
9 numbers of requisitionist as is appearing in annexure P4 at page 23 of the writ petition. আজ তার আগে না ওইটা লিভটা গ্রান্ট করার আগে মিস্টার দাসের সাবমিশনটা নোট করুন। মিস্টার গৌরব দাস, learned advocate, appearing through virtual mode, submits that the requisionists have not been implemented as a party respondent who are necessary party in the present proceedings. At this stage, learned advocate for the petitioner seeks leave to implead the requisionists. Leave granted, let the names of the requisionists as appearing in annexure P4 at page 23 of the writ petition be implemented as added respondent numbers 8 to
9 of them, 8,
11, 12, 13,
and I will be 17.
16, 8 to 16.
8 to 16.
8 to 16. Learned advocate on record for the petition is that to serve copy of the writ petition and in annexures upon learned advocate for representing the requisionists. Added respondents herein. Mr. Jahan appear করছে। Mr. Jahan.
I'm here.
Mr. Dash. Yes.
I'm here.
The petitioner contains that he is presently the Gram Panchayat of
Pradhan, my lord.
Pradhan of Gital Daho 1 Gram Panchayat. The requisition has been made within a period of 3 years of holding of office by the Pradhan, which is violative of section 12.
12, subsection 12.
Section 12, subsection 12 of the West
Section
Bengal
12, subsection 12 of the
West
West
Bengal
Bengal Panchayat Act
Amendment Act
1973.
2003.
And as such, the notice of motion dated 11th June, 1st June 2026 is liable to be set aside. Hence this writ petition. Mr. So and so, learned advocate representing the petitioner submits that such notice has been issued prior to completion of 3 years in office by the concerned Pradhan, who is a petitioner before this court. Hence the notice of motion dated 1st June 2026 issued by the prescribed authority, Block Development Officer, Dinhata 1 Development Block, Kuch Bihar, is liable to be set aside. He indicates that previously the period was 2.5 years. However, the same has been amended with a gazette notification dated 7th February 2026, extending the period to 3 years from date of election of the Pradhan or Upa Pradhan. Mr. Kunalji Bhattacharya, an additional government leader, at the outset indicates that the gazette notification annexed to the writ petition at page 27 within bracket annexure P6 is the amendment bill. The such bill has not yet got the assent of the governor, and the amendment of Panchayat, West Bengal Panchayat Act 1973 to that extent has not been given effect to as on date. Therefore, the period envisaged under Act of 1973 of 2.5 years still exists. The notice of motion has been issued by the prescribed authority, after expiry of 2.5 years?
Yes.
And therefore, the grounds taken by the petitioner is not tenable. Mr. Sarwar Jahan, learned advocate representing the added respondents requisionists, also submits in the similar fashion. He seeks for dismissal of the writ petition. It is found from the annexure, admittedly, the petitioner took the office of Pradhan on 11th August 2023. The requisition seeking for removal has been made by the added respondents requisionists on
25th of May 2026.
25th of May 2026, Annexure P4.
After
Pursuant to
expiry of
such,
2.5 years. After expiry of
pursuant
2.5
to
years.
such, that I will say later. 25th of May 2026, pursuant to such requisition, form of notice of meeting on motion for removal of Pradhan under Form 1E has been issued by the prescribed authority and Block Development Officer, Dinata 1 Development Block, Kuch Bihar, on 1st June 2026. In order to examine the issue as raised in the writ petition, it would be apposite to reproduce the relevant provisions of Section 12
Subsection
12 of the West Bengal Panchayat Act 1973 as hereunder. Upon bare reading of the aforesaid provision, it manifests that the it manifests that the meeting for removal of Pradhan or Upapradhan under the aforesaid provision shall be convened after expiry of 2.5 years from the date of election of the Pradhan. From the materials on record, it is found that such requisition has been made after expiry of 2.5 years and the notice of meeting has been issued after such expiry of 2.5 years. Therefore, the grounds taken in the writ petition falls short of merit. Accordingly, the writ petition being number such and such stands dismissed.
Grateful.
Extremely grateful.
Thank you. Well. Notwithstanding.
I'll take to them ये नामগুলো দিতে হবে amendmented নামগুলো
Thank you, brother. 31, my lords. I'm praying for not today, my lords.
31, Lordship, I'm for the bank, Central Bank of India. Lordship, we haven't received the copy. Kindly directed them to serve the copy.
Service has been complete, my lords. I have a affidavit service to that effect. My lord. Service has been complete.
Lordship, as per the direction, we haven't received.
What is this case?
As the matter pertains to when the petitioner has been selected to provide generator sets, my lords, to the Central Bank of India, Tufanganj branch. However, due to hike in the prices of petrol and fuel, my lords, the petitioner had prayed for further work. Thank you.
What is the order passed in the earlier writ petition?
To consider representation, my lords. To
Where is
consider
that?
representation, the petitioner accordingly had made a representation. However, till date, my lords, the representation has not been considered and an order has not been passed to that effect, my lords.
Evidence to have received enhanced rate for the generator sales. Bank has passed an order.
No, my lord, no order has been passed till date.
This in page 101, what you claim is something 40 lakhs. This is of enhanced rate or?
Enhanced rate, my lords, to keep the operations, the essential services operational, my lords. We have been making payments from our own pockets, my lords, which has accrued
No,
over
no,
time, my lord.
your claim of 40 lakhs or this is, you have calculated as enhanced rate or which was previously been settled by the parties? In page 101.
Yes, I can see that, my lord. That is a long time pending arrears, my lords, that have accrued due to the petitioner paying.
So why did you submit on the last occasion that the talks of settlements are going on? You have submitted in the month of April 2025.
Yes. Perhaps the settlements have failed, my lords.
Failed?
Talks of settlement. I need some instructions, my lords, and that is why I prayed for 1 day's accommodation, my lords. My senior is engaged in.
And where is your affidavits have been filed? You say copy has not been served?
Lordship, that has been instructed that we haven't received this copy.
You have sent copies to the bank?
Yes, my lords.
To the.
However, some may not have been, my lords, completed. I'm not sure, my lord. This was filed back in 2025. I shall serve them again. That is fine.
Learned advocate for the petitioner. Okay. Learned advocate representing the respondent bank submits that the copy of the petition and its annexures has not been served. Learned advocate for the petitioner undertakes to serve by the returnable date and its annexure upon learned advocate representing the bank. Bank is the answering respondent.
Yes, my lords. Respondent number 6, my lords.
And why you have this Secretary Kuch Bihar Generator Owners Welfare Association has been made a party? He has been served?
Secretary Kuch Bihar. What's there? That I.
File your affidavit of service. File your affidavit of service.
My affidavit service, my lords.
Okay.
Service.
Affidavit of service filed on behalf of the petition is taken on record. Respondent Central Bank of India is represented. Learned advocate submits that the copy of the writ petition and its annexures has not been received as yet. The learned advocate for the petitioner undertakes to serve copy of the writ petition and its annexures upon learned advocate representing the respondent bank. It is found from the affidavit of service. That service has not been effected upon respondent number 8. Petition is directed to serve upon respondent number 8 and file affidavit of service on the returnable date. Is this matter before the next available circuit court. None appears on behalf of the
Plus
petitioner.
32 also I'm playing for not today, madam. Kindly, just 1 day accommodation, madam.
What is this matter?
Madam, the matter is the petitioner is a company, madam. The West Bengal State Electricity Transmission Limited members has sought to construct a 132 kV single circuit transmission, madam.
Where?
Within Raja Tea Estate, my lords, which falls under the land of the petitioner company. The petitioner company owns, my lords. So the petitioner had paid for compensation, my lords. However, they have passed an order rejecting such demand for compensation. We have challenged that.
Any reports, copy of the reports are served upon you?
No, my lords. They were directed to file report, WBSC TCL. Report has not been served upon us.
And state you have served?
Yes, my lords.
All were appearing. Mr. Bhattacharya, this is a matter. I'm directing him to serve a copy of none appears on behalf of West Bengal State Electricity Transmission Company Limited. By order dated 10th April 2025, the report was directed to be filed by WBACTCL. It is informed that no copy of such report has been served upon the learned report has been served upon the learned advocate for the petitioner. Para Mr. Kunaljeet Bhattacharya, learned advocate, additional government leader, submits that the copy of the writ application be served upon the state respondents. Learned advocate for the petition is directed to serve a copy of the writ petition and its annexures upon learned advocate for the state respondents. And also inform the next date of hearing to learned advocate for WBACTCL. Please this matter. Next speaker. Next speaker. Next speaker 20th. 17th by 18th. 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 Next.
My lord, it's again a GTA matter, so my lords, fix it on 17th.
Okay. You are for the petitioner?
Yes.
Dekhi.
Also, I'm for the GTA.
Miss Radhika Agarwal, an advocate representing state respondents, submits that the writ petitions involving identical issues has been fixed on 17th June 2026. She seeks for fixing the matter on the said date. Accordingly, this matter on 17th June 2026.
Lordship, Union of India has served the affidavit on opposition today morning. So I need a fortnight time to reply the same. This is the copy of the affidavit.
Affidavit in opposition. Union is the
State.
answering respondent.
Union and the state state also, also, my my lord, lord. and what I understand, my lord, state has not filed. My lord, I will be praying for 4 weeks' time, my lord, fresh to file the affidavit in opposition. Another prayer, my lord, which I have is, since, my lord, we have not filed the affidavit in opposition, my lord, the maintainability point may kindly be kept open, my lord. And why I'm taking this point, my lord, if your lordship kindly sees, there are 4 writ petitioners, my lord, 4 private limited companies represented by 1 individual. Now, in the entirety of the writ petition, it does not say that which board resolution had empowered that particular gentleman to represent 4 different companies, 4 different companies having 4 different cause of action, my lord, 4 different lease agreement, 4 different MOUs. I don't even know, my lord, what court fees has been paid. So if the court fees has been paid for only 1 writ petition, my lord, then I'll request your lordship to kindly dismiss it right now for deficit court fees, my lord. And if court fees were all have been paid, then my lord will kindly grant us liberty to take the maintainability point in our affidavit.
Affidavit in opposition filed on behalf of respondent number 3 to 5 is taken on record. Learned advocate for the petitioner seeks extension of time to file affidavit in reply. Let such affidavit in reply be filed within 2 weeks. Mr. Kunalji Bhattacharya, learned additional government leader, submits that the writ petition is not maintainable since 4 companies have been arrayed as petitioners without there being respective board resolutions authorizing the deponent to file such writ petitions. He seeks to file affidavit in opposition. Let such affidavit in opposition be filed within a period of filed by the state respondents within a period of 4 weeks. A reply me be filed within 2 weeks. Yes, অনেক বেশি হয়ে গেল। ওই 3-2 করুন।
My lord, the court fees, my lord, I don't know if your lordship's officer kindly checks it, whether court fees is of 4 or 1. It will be around 800.
Acknowledgement shows rupees 222.
So therefore, my lord, I will kindly dismiss it for a deficit court fees, my lord.
Then let this argument come in writing. We'll respond to that.
No, argument will come in writing, my lord, but deficit court fees cannot carried on.
25th of February 2026, the court has already taken cognizance on this.
I am raising the point now, my lord. 4 causes of action.
Even if orders have been passed in the writ petition, the court has not decided on the aspect.
Grateful.
Lordship. Lordship,
So
if,
if there is a deputy court fees.
if there is
it can be
anything,
Granted to the petitioner to mend that.
Lordship
But you
will
cannot
find
say
that.
that once the cognizance has been taken, you will not be paying in court fees.
No, not that. If it will be taken care of, if the court orders, we will definitely find. No issue.
Mr. Bhattacharya's argument, I will note through. He also indicates that the petitioners have not paid proper court fees. Learned advocate, 212 is a proper court fees.
For a writ petition.
For
single
for
writ
one-
petition. For
For
a writ
one
petition.
undertakes to deposit ad valorem court fees if not already deposited. 3 weeks, 2 weeks, 5 weeks away.
My lord, maintainability point may be taken.
The point of maintainability as raised on behalf of state respondent is kept open and shall be decided at the time of final disposal of the writ petition. Liberty is granted to the parties to mention after expiry of such period.
Grateful. Great.
Affidavit has been submitted on the Union of India.
Yes. Respond numbers 5 to 2 to 5.
Yes.
Punch. After mention karo after expiry of such period.
नाम दे दिया है
Item number 55.
My lord, I am for the petition in item number 35.
Monday.
My lord, on 11th February, I have submitted the copy to the state, and till date, my lord, they have not taken any instruction. So I am only praying to consider my representation, my lord. Even yesterday also same thing took place, my lord. So it's a very simple matter.
On behalf of the petition is taken on record by the present writ petition. The petitioner seeks direction of respond number 3 to consider the application of the petitioner seeking transfer submitted through Utsosri online portal on 24th July 2022. Mr. Urijit Ghosh, learned advocate representing the state respondent, seeks
Respondent number 3 আমরা
accommodation instruction reads this matter. Next reads this matter on
DI কে forward করে দিয়েছে
Monday, 15.
No, one thing, the DI that we normally appear, he forwarded it to the commissioner. The commissioner is not appearing. We are appearing for DI and the state.
Who appeared? Mr. Roy appeared for
Yes,
the
my lord.
commissioner.
He appears usually.
If the DI has, then you have nothing to say.
DI has already forwarded, so he has done his job, my lord. Now this respondent number 3, he shall take the steps according as per my representation, my lord.
Okay, on Monday, you take instructions, on Monday you come back. And you also intimate Mr. Roy to be online so that this can be disposed of.
My lord, I already have submitted my affidavit of service. All the parties have been received, my lord. Kindly check once, my lord, my affidavit of service.
36.
My lord, item number 36, I am the petitioner number 2, appearing in person, my lordship, this is the affidavit of
कुणालित नहीं जागृति सर टाइम देना
My lordship,
Yes.
my lordship, this writ petition has been filed by me, my mother and father, my lordship. My lordship, this writ petition causes, my lordship, my father is an unpractitioner advocate who quit his practitioner since long, my lordship. And
Your father is a practicing lawyer.
no, my lordship. He did not practice at all, my lordship. Even a case, he even never do a case also, my lordship. So, my lordship, in the year of 2022, in our landed property where we resides, some people comes to
My lordship, can I submit in Bengali, my lordship?
Yes.
My lordship, এই 2022 সালে হঠাৎ করে কিছু লোক এসে আমাদের জায়গার মধ্যে দখলদারি 2020 সালে দখলদারি করে। ইভেন ওরা পেপারস কিছু দেখায়, তখন আমরা বুঝতে পারি না, তখন আমরা হাইকোর্টে আসি। আমার বাবা অলরেডি একটা ডিগ্রি পেয়েছিল, ডিগ্রি অফ ডিক্লারেশন অ্যান্ড পার্মানেন্ট ইনজাংশন। সেই ডিগ্রিটাকে ভায়োলেশন করি, ডিফেন্ডার্সরা ওখানে ঢোকে। তো তখন আমরা হাইকোর্টে একটা রিট পিটিশন করি, আমার বাবা করে পুলিশ ইন অ্যাকশন। আর সেখানে অর্ডার হয় যে ওনাদের এগেনস্টে ক্রিমিনাল এফআইআর রেজিস্টার করার জন্য, কারণ অনেক এফআইআর দেওয়ার পরও পুলিশ রেজিস্টার করছিল না। তখন সেটা আমরা কি নাম্বার হয়েছে, আমি আর আমার বাবা আলিপুরদুয়ার পুলিশ কোর্টে যাই, আর সেখান থেকে আমরা ডিটেলস নিতে গিয়ে জানতে পারি বাবার নামে অনেক রেজিস্টার সিওরিটি ফার্নিশেস হচ্ছে। সেটা আমরা ওই মুহূর্তে বুঝতে জাস্ট শোনার কথা বলতে আমরা বুঝতে না পেরে বড়বাবুর কাছে গিয়েছিলাম, আলিপুরদুয়ার ডিস্ট্রিক্ট কোর্ট, আর ওনার কাছ থেকে রেজিস্টার্ড খাতা চেক করে দেখতে পাই অনেক হয়েছে, যার মধ্যে থেকে বাবা কোনোদিনও কোনো রেজিস্টার্ড সিওরিটিতে না সাইন করেছে, না কোনোদিনও কোনো কেস করেছে। ইভেন উনি কোর্টেও যেত না, খুব মানে যেতই না বলতে গেলে। আমার মার বিজনেস আছে, যদিও আমার বাবাই ওটাকে হ্যান্ডেল করে, আমার মার নামে সেই বিজনেসটা।
কমপ্লেন লজ করেছেন?
হ্যাঁ, করেছি।
কোথায় করলেন?
পুলিশ স্টেশন, সিজিএম এট আলিপুরদুয়ার, ডিস্ট্রিক্ট জাজ এট আলিপুরদুয়ার, আর বার অ্যাসোসিয়েশন। ওনারা কোনো অ্যাকশন নেয়নি বলে একটা রিট পিটিশন আমার বাবা করেছিল, যেখানে
কমপ্লেনটা কোথায়?
মাই লর্ডশিপ, অ্যাকচুয়ালি এটার মধ্যে আমি যেটা চেয়েছি, এটার মধ্যে আমি কমপ্লেনটা দিইনি। এটার সাথে আরেকটা রিট পিটিশন কানেক্টেড আছে, যেটা পেন্ডিং আছে। আমি আজকে সেটা কোর্টে মেনশন করেছি ইন দি মর্নিং, মাই লর্ডশিপ। ওটার সাথে এটা ওই পিটিশনটার মধ্যে ওই সমস্ত ডিটেলস আছে, মাই লর্ডশিপ।
এখানে কি প্রেয়ার করেছেন?
মাই লর্ডশিপ, ওই তখন জবে থেকে এই জিনিসটা রিভিল হয়েছে আর ওনাদের উপরে অ্যাকশন হওয়া শুরু হয়েছে। অ্যাকচুয়ালি মাই লর্ডশিপ, যে রিপিটিশনটা করা হয়েছিল সেটা ডিসপোজ হয়ে গেছিল। জাস্টিস সম্পাদত্ত পর লাস্ট অর্ডারে বলেছিলেন যে অ্যাপ্রোচ বিফোর দি অ্যাপ্রোপ্রিয়েট ফোরাম। তারপর ওটাকে আমার বাবা অ্যাপিলে এসে চ্যালেঞ্জ করে বলে যে উইদাউট ফরেন্সিক এক্সামিনেশন পুলিশ ডাজ নট register the FIR. My lordship, that's why Division Bench Justice Jalpaiguri Bagchi has directed to send all these bail bonds to forensic examination and grant to the police authorities to 3 months time to come the report, my lordship. After 3 months, it is revealed that 64 bail bonds they already sent to the forensic laboratory, and it is revealed that all are forged, my lordship, not matched with my father's signature. Then Justice Devanshu Bosak passed an order to file the report before the district judge that how many bail bonds has been furnished in my father's name, and how the capacity gets increases. How the capacity get increases, still date not given any reply, but they are according to district judge's report, they said 2954 bail bonds has been furnished, my lordship. Then Justice Jalpaiguri Bagchi has said that who done gives the Division Bench has directed to the SP Alipurduar to investigate the matter. SP has created a SIT and investigate the same. After 6 to 7 months, they said that they can't do anything because pressure has been given to them to not do the investigation. They said this before court, and then Justice Rajshekhar Mantha has passed the order to send the investigation to the CID, and at present CID has been investigating from 19th May 2025, my lordship. Till date, CID has also do nothing, my lordship. There is a direction passed in the last MAT order by Shobbosati Bhattacharya to file the charge sheet. Even whoever they are, either lawyer, judicial officer, or court staffs. Even Justice Rajshekhar Mantha has passed the order to custodial interrogate to all the school staff or whoever they
মালয়েশিয়া যাদের উপর ওনাদের সন্দেহ হয় তাদেরকে সবাইকে কাস্টোডিয়াল ইন্টারোগেশন করার অর্ডার হয়েছে, অনেক অর্ডার হয়েছে, আমি যেগুলো এটার মধ্যে অ্যানেক্সার দিয়েছি মালয়েশিপ ইন দি পেজ নাম্বার 24, দেন মালয়েশিপ পেজ নাম্বার 30, 20 and 24 is the justice Mantha's order, my lordship. But none of order gets complied with, and the mat at last disposed of by the division bench, directing to file a charge sheet in the 2 months. But CID has not filed the charge sheet within that ordered time. After that, my father and I both preferred the writ petition before this court, which I mentioned today, my lordship, that is pending, my lordship. CID filed charge sheet against one lawyer, which filed earlier by the SIT, but division bench has said never one person can do this act. There is many pleas, but CID do nothing, my lordship, till date also. And there are মালয়েশিয়া ওনারা গ্রুপ হয়ে কাজ করছে, অনেক অত্যাচার করছে। আজকে 4 বছর হলো আমাদের যে ফ্যামিলি বিজনেস, যেটা দিয়ে আমাদের ফ্যামিলি ইনকাম আসে, সেটা বন্ধ করে দিয়েছে। আমাদেরকে ফিজিক্যালি মেন্টালি টর্চার দিনের পর দিন করছে, আমাদের বাড়ি রোজ রোজ ভাঙছে। ওখানে পুলিশ প্রোটেকশন দিয়েছে, ডিভিশন বেঞ্চ ম্যাট অর্ডারে জাস্টিস বাগচি পুলিশ প্রোটেকশন দিয়েছে উইদাউট মাই প্রেয়ার, মাই লর্ডশিপ। আমি প্রেয়ার করিনি, কিন্তু কোর্ট নিজেই দিয়েছে। আর টিল ডেট ওনারা আছেন, যার কারণে ওনারা থাকতেও আমাদের উপরে অত্যাচার করছে। আমাদের বাড়ি জানলা কাজ রোজ ভাঙছে, রোজ অত্যাচার করছে আমাদেরকে কোথাও কাজ করতে দিয়েছে না, আমাদের ফ্যামিলি ইনকাম বন্ধ করে দিয়েছে। ওদের একটাই কথা, মাই লর্ডশিপ, আমরা জানি এটাকে সেটেলমেন্ট করে এই জিনিসগুলোকে কোর্টের থেকে বের করে নিই। মাই লর্ডশিপ, ওনাদের কথা যদি আমাদের মানতে হয় তাহলে আমার বাবার সিগনেচার মেনে নিতে হবে, যেগুলো ওনারা জাল করেছে। ইভেন আমাদের ল্যান্ডেড প্রপার্টি ওনারা শিফট করেছে সিগনেচার জাল করে ওনাদের নামে। মাই লর্ডশিপ, এখানে আমার ফ্যামিলি মেম্বার্সরাও জড়িত আছে, যেটা আমার বাবার ভাইয়েরা পড়ে আমার বাবার দিক থেকে।
এই অ্যাট্রোসিটিস করলো, আপনি আবার এফআইআর লজ করলেন?
মাই লর্ডশিপ করেছি।
সেটা কোথায় কপিটা?
মাই লর্ডশিপ মাই লর্ডশিপ আমি এটার মধ্যে নিন, কিংবা আমাকে সময় দিন, আমি পরের দিন সাপ্লিমেন্টারি করে আমি দিয়ে দেব।
Let a copy of the brief be also given to the state university. We do not have a copy of the brief. We will look into it. All I know, my lords, is there is a checkered history. She has traveled up to the division bench, that I know. Division bench has passed certain orders, that is also we are aware. But right now, what is she claiming, my lords? We are in a total darkness.
In this writ petition, she says that there is a violation of fundamental rights as the facts goes on. So he has prayed for compensation. Compensation for the atrocities
If you would
upon
like
the
to have
family.
a copy of the brief, keep it on Monday, my lords. I do not think compensation is payable that way.
For mental agony, harassment also.
No. That is not possible. It doesn't fall within. Had it been a case of an illegal detention, a human right violation, I understand, my lords. There are DK Basu judgments and Nilabati Behra and everything. But in these manner, my lords, compensation has to be paid. That, my lords, is something very unknown to me, my lords. Let a copy of the brief be handed over to my office, my lords, today itself.
Okay.
We will have it tomorrow, day after, whenever my lordship wants. But, my lords, I am sure that compensation cannot be claimed in a writ petition in this manner.
Okay.
I will come with judgments.
By the present writ petition, the petitioner, affidavits are filed. Petitioner has sought for constitutional compensation, adequate constitutional compensation for grave violation. The petition number 1. One after Baba?
Yes, my lordship.
For grave violation of fundamental rights and for immense financial loss, mental agony and harassment, as well as distraction of livelihood. আপনার নাম কি?
সুনন্দিতা বণিক, my lordship.
সুনন্দিতা
বণিক.
Petition number 2.
Yes, my lordship.
Petition number 2, Sunandita Bonik appears in person. She submits at petition number 1 is her father and 3
Mother.
is her mother. Her father is a lawyer, but he never practices in court. The signature of her father was illegally forged by certain persons in the bail bonds. Investigations were directed by the order of this court. SIT was formed, and subsequently the investigation has been taken over by CID. The petitioners are facing threats regularly from the side of such racket involved in forging of the signatures of her father. On such ground, the writ petition is filed seeking compensation. We can write in the livelihood of the family due to such atrocities is also been affected. Mr. Jagriti Misra, learned Assistant Additional
Advocate General.
Advocate General.
I have to submit that there are two ways how compensation in these kind of cases are paid. One is human right violation, straight away writ court will interfere. Second is not by way of a scheme, maybe a victim scheme or something like that. This does not fall in either of those categories.
Submit, sir. The compensation is generally paid in case of human rights violation or when there is a scheme or under the act or of the government, such compensation can be paid
to the victim.
However, he seeks that a copy of the writ petition be served to this office. Two are different, or
to let it be served upon me, Milords. If she gives it today, tomorrow we will do it, Milords.
Served upon him so that he can make his response on Friday. On Friday.
I'm declared. Was a judgment around 37. Ownership item 37. 2 Milords item 34. All of this can be taken up together. Milords, yesterday I showed a judgment to my Lordship of the Madhya Pradesh High Court regarding how Milords the opinion of the High Court changes when the tribunal has already came into place.
37 is a challenge to what?
Item number 38 to 34, I'm saying for not because I've read yesterday your lordship also.
Today, it has been fixed for orders, Milords. Today, Milords, I am just relying upon one more judgment of the Allahabad High Court by a honorable single judge as to how the Allahabad High Court is dealing into issues like this. I would be pressing upon paragraph 2, paragraph 5, and Milords the ultimate paragraph 7. In paragraph 2, Milords the Honorable High Court says, the instant writ petition was entertained by this court as GST appellate tribunal under section 112 of the GST Act was not constituted for preferring appeal against order passed under section 107 or 108 of the GST Act. Now the central government by order that is such and such has constituted the GST tribunals and members have been appointed by the office orders that is such and such with a request to join their respective benches by such and such. Paragraph 5 says, once the procedure has been notified and appointments to the presidents and members have been made in the respective benches of the GST appellate tribunal, which itself indicates the functioning of GST appellate tribunal are put to motion, no useful purpose will be served in keeping the matters pending before this court. Then was paragraph 7. In view of the aforesaid facts and circumstances of the case, without entering into the validity and legality of the impugned orders, the writ petition is disposed of with the following directions. And these directions, Milords, are important. The first one says, the petitioner are permitted to prefer an appeal before the GST appellate tribunal as contemplated in 112, and there is a limitation up to until 30th June 2026. So what will happen is anybody who goes to the tribunal up to June 30, 2026, no question of limitation would be taken.
Okay.
So all limitations would be condoned if they file their petition by 30th June 2026. Second point, In case the appeal is preferred within the aforesaid period as referred here and above, the same shall be entertained without raising any objection with regard to the limitation. Milords, it is in their benefit that Milords, they go to the tribunal
Understand, Lordship.
and not to clog the High Court, Milords.
Here, Lordship.
They are wasting the time here, Milords.
And we keep the matter in the next week any day, madam.
No. We'll follow the.
Yesterday
plan.
also the
It
same
says that
request was
tribunal has
made.
been already set. by the-
Yesterday also the same request was made.
The
Milords.
GST.
Mr. Ghosh is engaged in court number 7.
I have shown Madhya Pradesh High Court, I have shown Allahabad, Gujarat is also of the same opinion, Milords.
As a copy.
This 37 is under 112 section.
Everything. Actually, what happens is there is a 73 or 74 order that is passed by the adjudicating authority. Against the order of the adjudicating authority, there is a 107 appeal. There may be situation where even a 107 appeal was not preferred because of the limitation. Be that as it may, after the order of the adjudicating authority without preferring an appeal or after the order of the appellate authority, everything has to go before the tribunal under 112.
Oh.
Can you give us a copy?
Everything has to go before the tribunal, Milords. These were entertained at the first place because the tribunal was not there.
Yes.
And because the petitioner couldn't have been left remediless. My request, Milords, let all of these matters be clubbed together and a common order be passed, Milords.
You are appearing for 38 to 40.
Yes, my lord, and I am appearing.
37 to 44.
37 my lord, I am appearing.
44, I am appearing for Union of India, Lordship.
For central authorities,
Mr. You just go through the prayers of the writ petition,
Yes, Milords.
whether particular.
In a brief nutshell, what my junior will do is tomorrow, item number wise, what is the remedy that has been claimed, whether appeal, statutory appeal was preferred or not. That we will give a timeline. But I beseech before my lordship, this has to 323B of the constitution is there. It has to go before the tribunal. They are simply wasting their time here. Even the tribunal has agreed to condone the limitation, my lords.
From yesterday, today, and now you are seeking time. I will fix it tomorrow. Then again you will seek for adjournment. What is it? 30th June is the time by which you can file the application.
Free of limitation. Free of limitation.
Already 20 days you have in hand to file the application. Liberty is granted, being granted, you have preferred it before the GST tribunal. What is the difficulty in moving the GST tribunal?
We don't have any illegal.
So if don't have.
And then
don't
after
have
the
any
GST
difficulty,
tribunal,
then
if they are not satisfied, then they can again come to the High Court.
Be disposed of. Why this will be kept pending? It's not that your right is being taken away. Liberty is granted to you to prefer the appeal before the GST tribunal. What is the difficulty?
And then as per 117, after the tribunal, they can come to the High Court. That is also there. Kindly have a look at 117, my lords. It's just that there was a stopgap arrangement. The tribunal was not there as in terms of 107. That is why 112. That is why they were here. They can again come back. The tribunal is in 112.
Yes.
Lordship, item number 41 to 44, we are appearing for Union of India, Lordship.
Item number.
Milord, I was only praying for a day's accommodation, Milord. Tomorrow, Milord.
Yesterday I have shifted it to today.
No, Milord, Mr. Mishra also knows, Milord, I was constantly on legs.
We exhausted in one of the division bench matter. We were together.
Sit down.
Can he takes it up tomorrow? I won't take any adjournment on whatsoever grounds. But I'll come and do the matter.
30th June, what I find from the order he has placed of Allahabad High Court. 30th
Yes,
June
I
is the
have
last date,
seen
so
that
there is no
judgment. I have
question of
taken it.
limitation.
I'll
I just passed order dismissing the writ petition with the liberty to the petitioner to approach the GST tribunal. That is
Right. Milord can pass the same order tomorrow. Milord, I'll just come back. Milord, I'll see this. I'll come back.
So, Mr. Mishra,
whatever my lordship says,
you just go through the list of that.
I will
appearing
prepare
under
that. I will
and
prepare
give a
I will
synopsis of the orders which has been appealed or appealed in the writ petition. We pass similar orders in all the writ petitions. Tomorrow, topic rekhe de. All these matters will appear under to be mentioned.
Lordship, 41 to 44, we are appearing for Union of India, Lordship.
Mr. Ghosh is appearing in
37. He is in 37.
You are in? Just not today, to be mentioned here.
Lordship, item number 41 to 44, I am appearing for Union of India, Lordship.
GTA. Are you for GTA?
Lordship, some item number
45. My lords, 40. My lords, it's again a GTA matter, so my lords may keep it on 17th.
GTA and state, both are parties here. There was a direction upon the state to file a affidavit, which is
This is also for regularization of
for regularization, but this is slightly different. The employees are all working under the sericulture department against sanction posts, and the selection process was regular. I'll just show 3-4 judgments. If the state does not come up with the affidavit, can take it up, because factually I don't think there will be a lot of difference. Well, I'll serve a copy of the petition. They say they don't have a copy, It's a short one. I can serve and come back tomorrow,
Not tomorrow, 17th, please.
Next week.
I don't have 17th. 17th.
Next
Instruction लेना पड़ेगा.
It's instructions required.
7 GTA का 45. I can 45.
Let it be placed on 17th. Lords. We are having all the matters on 17th. Regularization.
No, this is different. The issue is different. This is not for teachers. This is an entirely different department, entirely different selection process followed. And factually it is clearly distinguishable. So can take it up separately on any day. I'll serve a copy. If you don't have,
Let it have on 17th. Lords. The issue is different. We will treat it differently. All GTA matters 17th, dedicated day.
on 17th. Then. But they are not teachers.
No, not teachers.
Non-teaching.
Non-teaching. No, but not even non-teaching, they're working under the Sincona plantation, which is a different department of the GTA altogether. And the recruitment process was also different.
Mr. Misra, you just find out whether there are identical issues with that.
I will have a copy of brief from him, and then we will do it on 17th.
Advocate. Mr. Misra. Jagriti Misra, Assistant Additional Advocate General, seeks that the copy of the writ petition be served upon him. List this matter on 17th. In the meantime, the advocate for the petition is that to reserve a copy of the writ petition.
I'm out. I'm out.
Conroy.
I'm not on responding number 2.
Yes.
Yes, my lord. The writ petition is for reviewing the decision of an ombudsman passed in a complaint. Lordship, I have preferred a complaint under RBI scheme for being agreed by the service of the regulated entity, which is SBI. SBI, the deficiency is that, my lord, a banker's check was issued by the SBI, that is the regulated entity, following a succession claim made by the legal heirs of late Bonmont Rai. I am one of the legal heirs. And when the check was issued, I have, after receiving the check, I have deposited it. And after depositing the check, I found that the check amount was not credited in my account. So I made queries by filing an application that please explain why the check was not credited. It was the obligation, it's a part of service that the regulated entity should reply to that queries. But no reply was given. A reminder was also given, but still the regulated entity remained negligent. As a result, a cause of action has arisen that for making a complaint to the ombudsman. And that is why I made a complaint to the ombudsman showing that the regulated entity remained negligent in first clearing the check amount and then not replying to the queries of not clearing about the checks. So that was the issue. Now the ombudsman did a serious error in considering the complaint. The ombudsman
Amount was
observed.
lying in the name of your father.
No, he is my uncle and he was unmarried and he died without making any will. So there were 9 legal heirs.
Legal heir of second class.
No, my lord, that's
They are demanding money only
See,
because
order passed by the civil court.
civil court. But
whatever.
You are for respondent number 1
I'm for respondent number 2, State Bank.
and 1.
One is was represented.
Ombudsman,
but
my lord.
Ombudsman was represented, but today she's not appearing. I don't know why. She is the
Frequently, my
main
lord,
answering
frequently.
respondent.
Frequently,
I mean, the advocate who has appeared.
Abhishek Sarkar
I'm for State Bank of India.
and Miss Suchi Smita Ghosh.
Yes. She is not appearing today. She was
My lord.
virtually appeared last time.
Mentioning slip টা কোথায়? Mentioning slip টা কোথায়?
আপনি ওনাদের পাঠিয়েছিলেন?
হ্যাঁ।
You are Mr. Abhishek Sarkar.
I am Abhishek Sarkar.
ওই affidavit
এটা কাকে whom you have served it Devosh.
She is my sister. She is here. She is with me only.
Lordship, the affidavit of service has been
I think-
effected on the first day of the proceedings. That is
Lordship,
6th
I
April
think
25. Can
ombudsman
you
has
see the
not
order
been served.
dated 6th April? Subsequently, they were not.
In the morning, when you mentioned the matter yesterday, I asked you whether you have served the notice upon the learned advocates or not. What you have done is you have served notice upon the 2 advocates who are representing respondent number 1. Two.
See, my lord, what happened?
What about
Due
respondent
to,
number 2?
since respondent number 1 is appearing virtually from, probably from Calcutta, it's not possible to serve a copy. That is why I have emailed. As per direction of the Honorable Court, kindly see the order of the 19th May. There was a specific direction that the petitioner shall serve a copy to the respondent number 1. And if respondent number 1 remains absent, then the matter shall be proceeded in his or her
Respondent
absence. And kindly see the order dated 19th May.
19th May.
Yes, ma'am.
But answering respondent is respondent
Yes.
number 1.
Yes. And subsequently, they have appeared on the 21st May proceedings. And today again absent. So this is the whimsicality of respondent number 1. 19th May order, kindly see the 19th May order first.
Miss Suchi Smita Ghosh. She is a practicing advocate of this court.
Lordship, I don't know because I'm practicing only here.
Virtually appeared, my lord.
Actually,
Yes, virtually appeared on 21st May.
A fresh notice may also can given.
No, it cannot be done, my lord. Kindly see the 19th April order. What happened?
19th.
I have complied that. Also on record on the 21st May order, affidavit of service, there is also record of the affidavit of service. 19th and 21st order, 21st May order. When service is affected, how can it be notified? They are definitely following the cause lists. In the event respondent number 1 is not represented on the next day, the court may proceed in its absence. So the court may proceed ex parte. Because this is delivered, the absence is delivered. The record clearly shows this is a delivered absence.
Where is that copy? You're fine.
Yes, my lord, that affidavit of service on 21st May. 21st May proceedings.
Okay. Yes.
My lord, so my contention is that the ombudsman, while considering the maintenance of the complaint, has caused an error in considering the cause of action of the complaint. As per ombudsman, the cause of action relates to the issue of a mis-succession case, which is completely wrong. Can we see the cause of action is basically the negligence in service on the part of regulated entity in clearing the check. This is the issue. But ombudsman, kindly see page number 20, page number 12, my lord.
12.
Page number 12, the impugned order, the impugned decision of the ombudsman. Para 2. The grievance is against the regulated entity. It is observed from your submission and attachments in the complaint and the submission of the RE that the matter is related to mis-succession case number 6 of 2024, where an order dated that is issued to the by the learned court of the civil judge. As the matter is already dealt with by the learned court, no intervention from this office is possible. Therefore, the complaint is closed as non-maintainable. This is his observation and consideration. But actual cause of action is different, my lord. Can you see the complaint filed to the ombudsman, my lord, at page 14?
Where is the order of the civil court?
Civil court order is filed with, my lord, affidavit in service, affidavit of reply.
Page 25 of the writ petition, lordship.
25.
Page
No,
number
no, that
25
is
of the writ.
succession certificate. That is not the order. That is succession certificate, page 25. The order is at, my lord, affidavit in reply, the last file, affidavit in reply, page 6 and 7.
This is the succession
Your
certificate from.
name is? You are? Utpal Roy. 8.
Page 6 and 7, the order. Can you see?
Lordship may
Can you see the order?
found that
The
there is
order
no
part is
specific
clearly-
order or something we have in our hand. It's not a decree or something, which has been given in page number 25 and 26. It was also not clarified who are the class 1, who are the class 2 or class 3 successor of late. Who is the name? What is the
Let me
name?
see the order, civil court's order.
Civil court order is affidavit in reply, plus page 6 and 7, affidavit in reply, page 6 and 7. Can you also comparatively see the page 25 succession certificate.
6 and 7.
Affidavit in reply. Order but clearly states, my lord. Second paragraph page. The petitioners have been able to prove that they are the only legal heirs of the deceased Barmon Rai and they are entitled to inherit the scheduled mentioned assets as per the share, as per law of inheritance.
Leaving behind his brother is number one. Need more. Brother. Sisters, there is petition 2 and 3. Just not only 3. 4 to 10 legal heirs of the three brothers are Barmohan.
Also with a direction upon the petitioners to distribute the share among themselves as per their entitlement. These are the directions.
Receive the share among themselves as per their entitlement. Okay. In which account this will be credited?
No, that is not mentioned. Simply said in the order that the petitioners are entitled to that debt amount.
On which account?
Their individual amount, definitely, and that is why the bank has issued checks to individual to all the 9 years.
Issued checks?
Yes.
Where is that?
Issued checks. The check is
Lordship,
at page
Can I
number.
assist for a minute? Lordship. Kindly come to the page 25 of the writ petition.
Yes, ma'am. You can come. 25, not only 26 as well. 25 and 26. This is the succession certificate, my lord. Kindly see the rights and entitlements there in the end.
May I, Lordship?
Yes.
Lordship, in connection with Miss Succession case number 6 of 2024.
Yes.
This case was filed on 14th of June 24. Subject to correction of the other side or
Page
petition.
26, my lord.
Lordship. Then, as we know from the Succession Act, Hindu Succession Act, the first class of the legal heirs will get the first opportunity to get the successor of the property left behind by the deceased. Here, 1, 2, 3 is the brother and sister of the late Barmohan Roy. But 4 was struck down, but respondent number 5
Who is the deceased? Barmohan.
Barmohan was died. He's a brother of 1, 2, 3. And there is another 2 brothers named one Lolit Roy, wife of.
No. Only these 3 sister brothers.
Prabhat Kumar Roy and HON'BLE Roy is also the brother.
Yes, they are.
They have died long back in the year 13 and 2018. But this case was filed on 24 without mentioning the same. That's why this certificate came out.
Not mentioning.
So,
succession
if Lordship may understand, the Barmohan Roy, if died, his first chain of successors are the brothers and sisters, not their wives or their children's. So, when these both brothers were died, one of their successors is Mr. Utpal Kumar Roy, petitioner before your Lordship. I agreed that State Bank has made a mistake by distributing the money, some portion to the other successors who are not entitled to. But for that particular wrong, another person cannot take the benefit, which the petitioner is intent to. And that is the whole case.
Malad, then he should have been contesting any party representing in the succession certificate processing. Because when succession certificate application was filed, a clear mentioning was given, a clear representation was given by a learned advocate. Represented by the learned, representing the legal heirs, that these are the sisters alive, and these are the brothers died, and these are the legal heirs of the deceased brothers.
If so, then the mistake has been done in the civil court itself. Yes, we also must get the opportunity to replicate the same. But because of that wrong, someone cannot take the benefit of a writ court. And writ court is not supposed to take once again the matter in toto on the basis of in a trial. This is my whole argument.
Now, my lord, if anything wrong in that succession certificate or in that order,
that will be the subject matter of that court.
That person, those who are entitled to challenge those orders, have they challenged anybody? Have they challenged? No. So who is he, or what is his locus standi in presenting those facts? Has he any locus standi in presenting those facts or pointing to these issues, which has not been challenged by the appropriate or competent persons, if there is any competent person at all? If I am saying, because
how many checks have been issued?
9 checks, 9 legal years, 9 checks equally distributed the amount.
Wrong submission, Lordship. 3 of them is still date not received. Nirmal Chandra Roy, Josna Roy, and Utpal Kumar Roy has not yet been received. The second set of checks which has been issued.
That is the second. Now they come to the first.
The first time the mistake was done.
Page number
That's
22.
why.
No, whether it's
And that
mistake
because
or
of
not,
that
the court will decide.
If both start speaking, then I cannot understand.
Because of the said
Already he is
mistake.
deciding mistake without court's
Let him finish.
observation.
Let him finish, Lordship.
My point is that your lordship wanted to see where is the check. Page number 22. Kindly see page number 22. Page number 22 is the first check issued to all the legal heirs by equally distributing the debt amount or the total amount. That is 4,54,000 to all 9 legal heirs. And why it is, kindly see the submission of the regulated entity to the ombudsman, RD. That is at page, kindly see what did he say at page 32. It will clear the doubts. Page 32. Submission of RE to the ombudsman clearly says the succession certificate mentioned 9 legal heirs but did not mention the ratio or amount to be paid to each legal heir. The branch faced this issue in paying the amount jointly, and it was not possible to open a similar. So the bank issued 9 legal demand drafts to 9 legal heirs in equal proportion. That is his consideration. Nobody has said him. He has examined the succession certificate. He has seen the succession certificate. Subsequently, what he did, this is his first act, which is in accordance or in
Reading from which page?
Page number 32. I am saying the submission is submission to the ombudsman. Regulated entities submission to the ombudsman. From 4th line, it will be, your lordship
Yes.
can examine from 4th line.
4th line, yes. Read.
Yes. The succession certificate mentioned 9 legal heirs but didn't mention the ratio or amount to be paid to each legal heir. Now I am clearing, my lord. Then what is said in the succession certificate? Now kindly check it at page 26. What is said in the succession certificate? At the same time, that is the certificate accordingly granted you and allows you to collect those debts and to receive interest or dividends on, to negotiate or transfer. This is the point, my lord. I am here. Succession certificate clearly states or directs as per order. Also, as I just said, the order is as per order that to negotiate and to transfer the amount among themselves. In the order, as I have referred, succession case order it also clearly states that direction upon the petitioners to distribute the share among themselves. What is the error there? The successor, the learned court didn't make any error. The learned court clearly stated that I am directing you to distribute the share among themselves as per their entitlement. That means nobody can claim excess.
As per
excess
their
amount. As per their
entitlement.
amount. That is as per their share.
Lordship, lordship.
Schedule of the Hindu succession, if you're not entitled, you're not entitled to get the check.
Grateful.
As per their entitlement.
Yes.
So, as per their
You show me
entitlement.
that Hindu succession.
Now already they are
book I am
entitled.
not carrying
Already
today.
entitled. Already entitled.
No,
Success.
no, you are not already entitled. Since you are a petitioner, court has said that you get themselves shared among themselves as per their entitlement. That
Yes,
means
yes.
as per the act, if you are entitled, then you are get.
Yes. Kindly see page number 7, order part. Hello. The petitioners have been able to prove that they are the only legal heirs of the deceased Barmon Roy.
Hindu succession একটা দাও Hindu succession Your brother's son.
Yes.
And the other petitioners are
And also
sisters.
same, some are my sisters and some are another brother's. This is another brother's son and wife.
There are only one brother and two sisters of Barmohan Roy is still alive. His parents were died long back.
Brother and sister are included in class 1.
That's one. First his parents, then brother, sister.
Here also class 2. Brother and sister are class 2.
Class 2.
Yes.
Okay.
But in schedule, they are ever brother, son, sister, son.
Yes.
Take a দেখাও না।
Finally, can you see
Amina, Shahid
page number 7?
No, Mr. Sarkar ki to দেখো।
No, I understand. I might
What
be
is-
done some
what-
mistake.
what-
Father, mother, then brother, sister, and then their wife and daughter and children.
Has he written in the writ petition that 9 checks have been issued?
To the successors of legal heir, to the successor of late
Own
Barmon.
In which paragraph he has stated? That 9 checks have been issued?
Paragraph 9, my lord, you can see paragraph 9, page 5, paragraph 9. That the respondent number 2, upon receiving the succession certificate, has issued banker's check of rupees 4,54,000 to each of the 9 legal years by equally distributing the total debt amount.
Lordship may kindly also consider my bank's report dated 13th of April 2026. The total actual facts and incidents, Lordship may find in the second paragraph.
Affidavit in opposition.
Lordship, I just filed the report with the instruction of the court.
Yes.
My lord, kindly see the report paragraph second. Dot one. Seventh line, but fortunately after receiving the said check, one Pratima Roy.
I
one
request
of
this
the
honorable
legal
court to read the paragraph in toto.
This is the specific, very significant part.
This is your report dated 13th April.
Lordship, there was a mistake from the side of bank. I agree to that.
Yes, Malak Ali addresses a very significant point, but fortunately after receiving the checks, one Pratima Roy indicated that the equal distribution will create incorrect distribution as per succession rights, and thus all the legal heirs returned their checks.
As much her understanding.
Except,
As much her understanding.
no, okay, except Mr. Utpal Kumar. Yes, Pratima Roy is also one of the legal heirs who also comes from brothers. This is brothers' daughter.
That is what I told Lordship, that there was a mistake from the
Now, my
bank
lord,
also.
now, my lord, come to the
But
point.
for that mistake,
But
somebody cannot
unfortunately-
take the benefit
Pratima-
of that
Pratima
which
is
is
your-
not entitled to.
My cousin sister. That means the deceased Barmon I had
If Lordship wants, I
three
can
brothers, one
transfer
alive,
the
two
tree.
brothers died. We are from the deceased brothers. Now, my lord, come to the point.
Lordship, if Lordship wish to see,
Go
I
back
can
to the-
show the tree, but there is some marking. If your Lordship may wish to understand. Dada, see that.
Pratima Roy is a party herein. Pratima Roy has been made a party.
No, why Pratima Rai would be a party in this case? Pratima Rai is one of the legal heirs who has raised, my allegation is specifically against bank section and no legal heirs are there. Pratima Rai had no knowledge that the succession certificate has entitled the legal heirs to negotiate and to transfer the amount themselves as per their share. That
So
is
they
why
have
maybe
returned the check.
he raised,
Is any application has been filed by the legal years, other legal years before the civil court seeking for clarification?
Lordship, I don't know
yes.
that.
that is
We don't
no,
know that. We don't know that.
No.
Mr. Roy, please hold on.
yes.
Please.
No, there has to be some record now. What is not on record? Why?
I am
can it be-
asking him whether any application has been filed.
Yes, that is the point.
The report says that other legalists have returned their check.
Hmm.
They have some dispute as regards equal distribution.
Lordship.
Let
That-
me inquire from the bank whether any application has been filed.
On the civil court. At the
Yes.
civil. court.
Lordship, I don't have that any paper in my hand. Allow me some time. I can clarify from the bank and
Or you
answer your
clarify the
queries.
court on the next date whether any application has been filed by other legal years seeking for clarification before the court. Civil
No,
court.
to the best of my knowledge.
If it is not, then you file an application seeking clarification of your entitlement.
Entitlement.
Yes.
My-
I dispose
my-
of the writ
my
petition granting
explanation
him
is
liberty
very-
to file an application, appropriate application before the civil court. Let the court decide what is the entitlement.
Very well. I'm
Who
grateful.
will file? Who will-
You have to file an application
Where? Court.
before the court seeking clarification.
Why I do seek clarification? The court has already
If you don't
decided.
seek clarification,
Now
then
it is
then
whether
we have
to,
to go by the succession
now
certificate.
my lord, whether I have to accept this certificate or I have to challenge it.
Mr.
I am
Sultan, find
accepting
out
this.
Any application whether have been filed or not.
I don't think so. I don't think so. Nothing has been handed over to us yet.
We have accepted this certificate, this order, and that is why we have made succession claim. The legally, that is why filed succession claim. Why otherwise, why we would file the succession certificate? Succession claim, why we will make a succession claim? Succession claim made was jointly made upon receiving the succession certificate. As per the succession certificate, the submissions are made and bank issued checks. Now, after, if somebody has no knowledge
Just
that.
find out and inform
Lordship.
the court whether other legal years have filed any application seeking clarification.
Lordship,
Because they have
Lordship.
returned the check.
I understand. They
Your
returned
report
the
says
check.
that it has been returned since they have a clarification from the bank whether equal distribution has to be made or not.
Lordship.
Court has said rightly that as per entitlement.
No, my lord,
Lordship.
then why?
Please.
Okay, it
shouldn't
can
they
be
be-
said, it can be said, you can say this, but what would mean
No,
when it says, what would mean when it says that, direction upon the petition